to attract the best and the brightest to join the judiciary. If I may, again, relate to you just one short anecdote. 2 weeks ago, I asked my class of 40 students, I said, okay, ladies and gentlemen, I said, how many of you, potential lawyers, want to be judges? Out of the 40, only 2 raised their hands. And they said, I want to be, sir, but only if Supreme Court. Now, I think this was not how it was during my grandfather's time and my father's time. Being a lawyer, being a judge was a position of honor. It was looked upon with great respect. But nowadays, I get the sense, having been teaching law for over 20 years, that is not anymore the priority of our law students. That they only go to the courts in case they don't make it in practice, which is not how it should be. As I said, for our justice system to work, it must be able to again attract the best and the brightest.
Okay, related to that incident that you just mentioned, Dean Bautista, do you think that the present law school curriculum provides sufficient training to law students who want to pursue a career in the judiciary?
Yes, it does. Although, again, I hasten to add, and now there is a change from the rigid LLB to the more flexible JD, which I think is a step in the right direction. Essentially, the two are the same, except that JD allows a law student to specialize in a practice area earlier on. So, for example, if it is really a law student's dream to be a judge or to be a litigator, he or she can focus the subjects that he or she takes to litigation-related areas. On the other hand, if you want to do corporate law or you want to do tax, then you can take subjects that are related to these areas of specialization. I think this is a step in the right direction. This is similar to what's going on in medicine. So, in terms of the curriculum, I don't think there's anything wrong, although I think we should encourage law schools to be more, to find their niches, to look for their areas of specialization, like what is happening in foreign law schools.
Why should the president appoint someone from the outside? I mean, let me be more specific. There is an apprehension that if someone is appointed from the outside to head the Supreme Court, there will be massive demoralization within the Supreme Court. How will you address that concern?
That's an excellent question, Professor Mejia. I think if you ask me, all things being equal, the next Chief Justice should be an insider rather than an outsider. And why is that? Because again, if you look at other institutions, you would like to convey the message that people can rise up the ranks. And also, you have issues in relation to experience, that somebody who has been there knows the problems and should be able to tackle these problems better. But I must say that this situation we are in is unusual, in the sense that all of a sudden there was a vacancy which was not planned. And as I said, part of the problem, if I may say, that the impeachment that happened was not, to me, just an impeachment of a person, but the impeachment of the entire judicial system. And that is where an outsider might be able to help. He or she may be able to bring a breath of fresh air, a new perspective as to how things can be done. As I said, I think that the Supreme Court should realize that there is a credibility issue that it is facing right now, and that it cannot be just business as usual. We must do ways and means in order to repair that integrity, and I hope that choosing the Chief Justice is the first step towards that improvement.
That's my final question. Good luck, Dean Bautista, and thank you, Mr. Chair.
Thank you.
Justice Langman.
Thank you very much, Mr. Chair. Dean, is it Dean or Chairman? How do you
Kahit
like
Andy lang po, okay na.
No.
Kasi po minsan, alam nyo, isa pa yun, yung titulo.
Yeah.
Dito sa atin, minsan masyadong hang up yung mga tao sa titulo.
Yes.
Ako, Andy lang
But
po, okay lang.
you cannot avoid the fact that you are the chairman of the PCGG. and a dean of a prestigious law school.
Salamat po.
So, I will call you chairman. Okay. Now, I know that you have answered the question of Attorney Cayosa regarding your age, but I feel that I still want to ask you this question. At the age of 48, if you will be appointed as the next Chief Justice, you will be serving the court in that position for 22 years, which would effectively deprive all the incumbent associate justices of ever being considered for promotion to that post. Okay, under that situation, if you will be the Chief Justice, how are you going to lead the court and get the respect, the trust, and confidence of the incumbent associate justice to enable you to lead the court with moral ascendancy? Okay.
Thank you for that question, Justice Lagman.
Yes.
In fact, that can be bad if you have a bad person who is in office for a long period of time.
Yes.
But to address that particular issue, in fact, I believe that there should be judicial term limits. In the same way that there are term limits in the executive branch, there are term limits in the legislative branch. We copied this sitting until 70, or as you know, in the U.S. Constitution, it is not just 70, but until they are able to. Okay, we copied that from the U.S. Constitution, but we have to remember that at that time the U.S. Constitution was ratified in 1791. I think that the probable age of people then, their longevity was only in the 50s. Yeah. And that's why they were not expected to live long. No? Yes. But to my mind, well, that one, by the way, is already being challenged. There was a recent survey in the U.S. which showed that 66% of U.S. adults believe that that should be amended and that there should also be term limits in the judiciary. So if you ask me what I would propose, we should have a 770 rule in the judiciary, meaning that term limit of only 7 years, regardless of what age. And once you reach the age of 70, then you have to retire. Okay? And as in the same way that you asked all of us candidates to sign a waiver of our bank accounts, I am also willing to sign a waiver to say that I will only serve for 7 years, if appointed.
Okay. Thank you very much, Chairman. Now, I'll go to another point. We all know that the impeachment of the former Chief Justice has affected the judiciary in a way. Now, in your opinion, what kind of a Chief Justice do we need today to regain the respect, the trust, and confidence of the people, and to restore the cordial relationships of the judiciary with the other branches of government?
I agree with you, Justice, that indeed I think that the impeachment caused a disruption in terms of how our justice system works. Mm-mm. But I believe that this disruption is actually healthy. Mm-hmm. And to be honest, I have read papers saying that maybe we should have a healing Chief Justice at this point. I think that is not yet time. I think there continues to be problems and issues that the judiciary faces that also needs further reform. So yes, again, at some point, people should learn to disagree without being disagreeable. If people are just very professional in the way they do things, I don't think there will be a problem. Okay? And insofar as being able to ensure that the credibility is restored and maintained, to my mind, the solution is changing culture, changing attitude, and changing mindset. That the courts should be more transparent in the way they do things. They should be able to get buy-in and participation from the public. They should get the people more involved in their operation so that the people are not kept in the dark. Because I think that's part and parcel of the problem, that the Supreme Court is seen sometimes as a mystery, as as an old boys club, as secret society and things like that. The way to do it is to open it up. One of my favorite sayings is, sunlight is the best disinfectant. Open it up, let the sun shine through, and I think that the credibility of the court will be restored.
Okay, thank you very much. Now, if you will be fortunate to be nominated and appointed as the next Chief Justice, what would be your top 3 priorities upon assumption of office?
If I may reiterate, Madam Justice, first overhaul HR, human resources.
Okay.
Attract the best and the brightest. Because as I said, the work that an agency does is only as good as the people who do them. Number 2, finally fix the case congestion and delay. That to me is the biggest practical issue facing the courts. And I said, I shudder when I think about the economic repercussions of this delay. And then finally, after all is said and done, the Supreme Court should lead by example. Lead by example in terms of wiping out its own backlog, leading by example in terms of accountability and transparency, leading by example by being more adept in using technology. I think technology is a tool that can be used in order to ease the burden of the work of the Supreme Court. And as I said also, the Supreme Court should really reach out and let its hand go through and speak to the other stakeholders so that we may be able to really show what it's trying to do, and after its performance, it's able to really assure the people that it is here to try and improve our justice system.
Okay. Chairman, my last question. I feel that I have to tell you this to be fair and to give you a chance to comment on this publicly. Yesterday, actually this was received by our office on July 20. A letter was filed by the Philippine Overseas Telecommunication Corporation. What is this? The PhilComSat group of companies and the PHC through their counsel, Attorney Kapunan, opposing your nomination to the position of Chief Justice. Now, they allege that your refusal to abide by the resolutions and directives of the Ombudsman, the Supreme Court, the PCGG itself, and the Department of Justice has caused irreparable damage to these corporations. Do you want to comment on this?
Yes, of course I do, Madam Justice.
Okay.
In a strange way, I welcome this opposition because it gives me again an opportunity to preach the gospel of good governance. They were saying that you're probably not doing your job in government unless a case is filed against you. So be careful what you wish for.
Yeah.
To me, it is a badge of honor if a case is filed against you wherein you are trying to protect government interest. Just by way of background, those opposing my nomination, Mrs. Erlinda Ilusorio Bildner is the president of PhilComSat. She is the daughter of Potenciano Ilusorio, who, according to PCGG records, was a Marcos crony. And then the lawyer who signed it, Attorney Lorna Pataho Kapunan, also, she was the daughter of a Marcos classmate, former COMELEC Commissioner and Justice Lino Pataho. One of the problems in PCGG is that you get mixed up with people from the Marcos regime. And again, most of them are back in power, and that's why it is very difficult to go against them. But just for the record, the current PCGG, okay, has, if you look at the allegations, if you look at the dates, it's all before September 2010. So we have done no wrong against PhilComSat. In fact, the funny thing is that I have been elected the chairman of POTC in September 2011, up to now. But under the bylaws, only the president and 2 members of the board can call a meeting. It is what, 10 months already? No board meeting has been called. Also, in respect of, again, we have not received a single centavo from PhilComSat or POTC. What we're all asking from the current management, okay, is that they be transparent and accountable in the way they're managing the company. The government has a 35% interest in these companies, which was surrendered to the government, to PCGG by the group of Mr. Campos. We just want to protect that interest. And that's why I challenge both Ms. Bildner and Ms. Kapunan. Let's have a full-blown Senate investigation on this matter, because I would be more than willing to meet whatever opposition they may have.
Okay. Thank you very much, Chairman. And that is my last question. And good luck.
Thank you.
Justice Hermosissima.
Good morning, Dean.
Good morning po, Justice.
We acknowledge the arrival of Congressman Tupas.
Thank you.
Your impeccable credentials, academic credentials have preceded you, sir.
Salamat po.
In the Supreme Court, cases are raffled to individual justices. In the Court of Appeals and the Sandigan Bayan, cases are raffled to the divisions through their respective chairmen. Which method of dispensing justice is your preference?
If you ask me, Justice, I think both are doable. Again, to me, the key is just ensuring that the rules are clear as to how the raffle is being conducted. And here you have to strike a balance between confidentiality and transparency. So you have to ensure that there is a certain sense of confidentiality so that justices and judges cannot be approached. But on the other hand, you also want to restore credibility in the system. And I think that the way to do that is to be transparent in the way you do things. So whatever be the rule, let's just make sure that people are made aware of them.
In the latter method, the chairman will have the power to farm out the cases to justices more expert on the subject at hand.
And aside from that,
however, the procedure will give rise to, or give the opportunity for graft and corruption. So, what are your thoughts on this point?
Well, graft and corruption, not necessarily. I think it makes sense that a justice who has a certain expertise should be tapped in order to write decisions on that subject area. Also, I think that the other thing we should consider is the cases that justice is handling, that we should try our best to ensure that it is evened out, that so that they will not complain about workload. We should try to distribute cases in accordance also with the workload and with the area of specialization.
On another matter, presently, cases which are not necessarily decided en banc are decided by a division of the Supreme Court. The decision of the ponente in that division is considered a decision of the whole court. There are objections to the manner of deciding cases, to this manner of deciding cases, because it is felt that the decision of a division is not reflective of the sentiment of the whole court. What are your thoughts on this matter?
Well, Mr. Justice, first of all, I think this is one of...
Would you agree to the proposition that all cases be decided en banc instead of by division?
No, I don't agree with that, because I think that will lead to further delay and congestion into our legal system. In fact, I would also advocate perhaps a system similar to the United States, wherein the Supreme Court should be given the prerogative to choose the landmark cases that in which it wishes to take up and provide a definitive ruling on. That right now, everything needs or has to go up to the Supreme Court. And I think this is not healthy. Now, insofar as the decision of a division being a decision of the court, I think that that's the right direction. That again, why does everything have to go to the court en banc? Now, but there have been instances wherein a decision of a division has been overturned by the en banc. Perhaps in certain exceptional and meritorious cases, that should be done, but it has to be done in a very transparent and accountable way.
Well, if we have to compare the decision, the cases in the United States Supreme Court and the Philippine Supreme Court, it has been said that in the United States Supreme Court they are deciding only 100 cases per semester. But why is it that even ejectment cases go up to the Supreme Court? Why does the Supreme Court not decide only questions of law? As it is, we are deciding cases on questions of fact. If we be strict with that, then there will be a limit to the cases before the Supreme Court.
I agree with you 100%, Justice, that we should amend the rules so that these frivolous cases should no longer be brought up to the Supreme Court.
It's not really this is the rule, that only the Supreme Court decides only on questions of law. But we are deciding cases on questions of fact. Well, on another matter, since you are an expert in constitutional law, do you believe that there are many provisions in the Constitution, 1987 Constitution, that need amendments or revision?
Yes, I do.
Do you agree to the convening of a constituent assembly to amend the Constitution instead of a constitutional convention?
Well, Mr. Justice, I don't know, but I wrote a column on the matter last Saturday, and I proposed again
I'm sorry, I missed that.
So it is again
I'm always reading your columns.
It was entitled Chartering Change, and I was saying that perhaps we can have a hybrid mode. This is like it will use the Constituent Assembly provision, but Congress will not convene unless and until there is already a buy-in on the specific amendments that will be passed. Meaning that they can only convene as a Constituent Assembly if they agree to amendments that had also been pre-cleared with the people. So in this mode, what I was trying to meet were the two objections of, number one, distrust, the issue of distrust with respect to Congress. With all due respect, Representative Tubas, but it would seem that the people are not very comfortable with Congress undertaking the amendments or revision of the Constitution because they're not sure what provisions will be amended. Second, there is also the issue of distraction. That I think this is the main issue of the President. That if we go through a constitutional change exercise, it might distract the country from the pressing matters that it is currently trying to undertake. So my suggestion was, let a non-governmental private sector group convene itself, come up with these amendments. It's not very difficult. There have been so many studies that have already been made. Come up with a document. They should consult with the stakeholders, consult with government as well, and then come up with amendments that people can agree on. And then meet with the leadership of Congress and tell them, okay, these are amendments that we can support. And at that time, perhaps the leadership of Congress can agree. Then they can constitute the Constituent Assembly. And then they can pass these amendments, hopefully in time for the 2013 congressional elections, so that we don't have to spend for the plebiscite.
Suppose it is decided that it be a Constituent Assembly. To amend or revise the Constitution, will it be with the Senate and the House voting separately or jointly?
Well, Mr. Justice, as we know, again, that is one of the editorial lapses that happened in the 1987
Correct.
Constitution.
Correct.
And Representative Tupas is fully aware of these lapses. No? If you ask me, I think that the more prudent interpretation would be that they should vote separately, because that will go hand in hand with the other provisions in the Constitution. If I'm not mistaken, there is only one provision which calls for both houses voting jointly, and that's in Article 7, Section 18, I think, in respect of martial law. So it would seem that the intent of the framers is to have a separate voting. But once again, this is one of those editorial lapses that we should amend so that no more issues in respect of who will get to sit in the JBC will need to be addressed in the future.
In other words, you agree with Father Bernas that in order to solve the problem, the amendment should first be taken up by the House and later to be approved by the Senate.
Not necessarily.
Would that be feasible?
Not necessarily, Justice, in the sense that I think both houses, both the House of Representatives and the House of the Senate, should take it up independently, but not necessarily the House first and then the Senate. They can take it up together.
Dean, let's go to a subject which is nearer home, closer to home. The City of Manila Ordinance Number City of Manila Ordinance Number 8027 reclassified parts of Pandacan from industrial to commercial zones, thus mandating that Filipinas Shell, Chevron, and Petron to transfer their operations elsewhere. Those opposing the transfer argue that the transfer would disrupt oil supply and cause an increase in oil prices. The Pandacan Oil Depot supplies 1/2 of the country's fuel demand and 100% of lubricant requirements. The transfer would result in the loss of jobs of hundreds of thousands, not only the big three, but also of Unilever, Finco, etc., which would have been forced to move out of the city. The city of Manila would lose 66 million yearly in revenue if the transfer is pursued. Yet those who want the transfer argue that the oil depot poses a danger to life and limb and the safety and health of Manila residents. It might cause a disaster and devastation, a devastation worse than that of Typhoon Sindong, caused by Typhoon Sindong. By the time you reach the position of Chief Justice of the Supreme Court, if and when you will be appointed, the issues involved here will still be ripe for discussion and resolution. What are your thoughts on the matter?
Before you answer that, Dean, may just remind Justice Hermosissima, sir, that will be your last question. Your time is up. That will be your last question, or you're going to ask another question after the answer of Dean Bautista?
Well, I hope you'll give me more time.
We'll just allow you another question after this, after the answer of Dean Bautista.
If that's your wish.
Go ahead then. I'm sorry, you got, and then you go now answer the question of the justice.
Although with that question, Justice, I really feel like now a law student being asked to recite. Wala po bang multiple choice? A, B, C? No, seriously though, this is a multifaceted problem. As we know, it's not just legal issues that are in play, but there are also financial and economic implications. There are employment, livelihood, opportunities that also must be taken into account. These are the things that I think that the Supreme Court should really consult with other stakeholders whenever they make decisions in respect of matters of paramount or transcendental importance. And here, if I may add, this is where I think I have a bit of disagreement. No? In respect of the power of the court to settle actual controversies involving rights which are legally demandable and enforceable, and to determine whether or not there has been grave abuse of discretion amounting to lack or excessive jurisdiction on the part of any branch or instrumentality of government. This is Article 8, Section 1. I think that the court has swung too much on the other side. That during the time of President Marcos, the complaint was the court was too timid, was too deferential to the executive. I think, though, after this provision was inserted by Chief Justice Concepcion in the 87 Constitution, the court has become too aggressive, has been intruding in matters over which it probably does not have the necessary expertise. So if you ask me, I think that the court should strike a right balance. Again, that the political question doctrine is still alive. As far as I'm concerned, there are certain matters that are best left to other agencies of government. That is the kind of philosophy that I would expound. And if you ask me, I think we should amend Article 8, Section 1. We should take out that grave abuse power and just bring it back to the original, because that alone gives the court already the important power of judicial review, and hopefully send a signal to the court that it will be able to re-examine its role within our constitutional framework.
I was hoping you will answer my question.
Well, my answer, again...
you had answered it indirectly.
Yes, Mr. Justice, as I said, the problem is that there are many factors and variables that you really have to study in the situation that you had mentioned. I think that it would be difficult for me to give you a off-the-hip, gut-feel answer. I think, though, that as you had pointed out, these issues should be reviewed, and that we should speak and consult with the other players so that we can come up with an informed judgment regarding the case.
Last question,
All right.
Justice.
The tremendous inherent power in the hands of the Chief Justice and the Associate Justice of the Supreme Court require that those appointed to the position should possess the highest degree of competence, integrity, and judicial prudence, because the administration of justice is a sacred task entrusted only to individuals with the highest degree of competence. A judicial post is a position of honor and is offered only to those who are best qualified. Considering this, if you are appointed Chief Justice of the Supreme Court, what would be your judicial philosophy?
Well, I think I had provided a bit of a preview of that philosophy. As I said, I think that the court should rethink its role in light of the constitutional framework, as well as also in light of the current needs of society. That, again, for our tripartite separation of powers system to work, the court has to protect its independence, but at the same time realize that it is interdependent with that of the other branches, for so long as we are all promoting the common good. So I wouldn't say, when they say that the court is the least powerful of the branches, as we all know now because of Article 8, Section 1, that is probably not so. But on the other hand, I will not also say that the Supreme Court is the most powerful, because the executive continues to have the power to implement, and Congress has the power to appropriate. So I think that what we need to strike is a healthy balance among these three branches. I've also stated earlier that I felt that the court has become too activist in the way that it decides cases. I think that they should step back a bit, okay, and allow the elected representatives, directly elected representatives of the executive and the legislative branch, to craft the policy.
Dean, can you shorten that? You see, when you enter the portals of the Supreme Court of the United States, you will find emblazoned the words equality under law. That may be the judicial philosophy of the Supreme Court. Well, here in the Supreme Court, what do we say? Batas bayan.
Okay.
Do you agree with the motto of the Integrated Bar of the Philippines, which says, no master but law, no guide but conscience, no aim but justice? Do you abide by that motto?
It is a beautiful motto, Justice.
Okay, is that all, sir?
But can I also give you the one which is again very beautiful also in the U.S. court? Fiat justitia rua celum. Let justice be done, though the heavens may fall.
Okay.
So in short, what is your judicial philosophy?
Not in long, no indeed one.
Do what is right.
Okay. That's all, sir? Justice? Okay. Now, upon request of Congressman Tupas, Secretary Muslim, you will first ask the questions before Congressman Tupas.
I get my water, Mr.
I thought you want to sit already.
Okay na, nandito na.
Okay, go ahead.
Yes, Mr. Chairman, thank you very much. For anything else, I'd like to disclose, of course, that Andy Bautista is a former batchmate of mine in the graduating class of 1986 at the Ateneo de Manila College of Arts and Sciences. He is also a former a classmate of mine at the Ateneo School of Law, and of course a personal friend. Magandang umaga, Dean Andy.
Magandang umaga po, classmate.
Much of my questions, Mr. Chairman, has already been previously asked by some of the members of the panel. So I have reduced my other questions to about 3 or 4. Dean Andy, ano sa tingin mo ang halaga at responsibilidad ng punong maestrado at ng hudikatura sa ikauunlad at ikaaangat ng buhay ng bawat maralitang Pilipino sa ating bansa?
Sa akin pong palagay, no, na, and perhaps this is part and parcel nga of my judicial philosophy. Again, I think na ang ating batas dapat merong preferential option for the poor, the marginalized, and the underprivileged. I think this goes hand in hand with that shibboleth popularized during the time of President Ramon Magsaysay, na those who have less in life should have more in law. And why does this make sense? Because in reality, those who have more in life have less need of the law because they are able to get their rights protected on their own. Kung kaya't sa akin pong palagay, dapat meron tayong bias para nga sa mga mahihirap, para sa mga mararita. Pero wag din nating hahayaang inaabuso ang kanilang mga karapatan o yung kapangyarihang binibigay sa kanila. For example, yun na lang sa pagwewelga. Okay? Yan ay isang mahalagang karapatan. Pero again, pwedeng abusuhin. So sa aking palagay, importante na naman ay balansyado. Dapat merong balance. On the one hand, there is the police power of the state. On the other hand, there are the individual rights of the citizens. We need to create a healthy balance between the two.
Maraming salamat. Sa pangtanong, you earlier characterized the judicial system as inadequate, that it is inefficient, it's a bit broken. These seems to be very negative observations. I will deem it that you have constructively criticized the system as it is right now. But could you, however, cite reforms, if you know of any, that are being implemented by the judiciary under the previous Chief Justices that are worth continuing to be implemented should you be appointed Chief Justice?
If that was the impression, Mr. Undersecretary, I wish to correct that impression in a sense that, yes, I believe that the system is broken. But on the other hand, there have been several good projects that have been undertaken by past Chief Justices. For example, I think we should encourage the continuing use of court-annexed mediation. I think that if you look at the figures, it has shown that it has successfully diverted certain cases so that they no longer join the docket but are resolved outside of the court system. There is also JDR, Judicial Dispute Resolution, which again, the judge takes a more proactive role in trying to settle disputes. The creation of small claims courts is something that we should also look at. ADR, Alternative Dispute Resolution, and in fact in Singapore now they have ODR, Online Dispute Resolution, which would allow parties to settle their disputes through the internet. Again, there have been several projects that have been undertaken towards trying to clean up our system. But really my frustration lies in the fact that, as I said, there was that mandate in the 1987 Constitution. 25 years later, that mandate has not been fulfilled. I look at other countries. This problem of backlog has been faced by other countries. It was faced by Singapore in the early 90s, but look at their system now. It's world class. They were able to find a solution to these problems. So as far as I'm concerned, perhaps this was my youthful exuberance expressing frustration. But I also would like to think that perhaps it's about time that we solve these problems once and for all.
Can we go back to the point of you being an outsider applicant? Just to phrase this one, on July 16, 2012, the IBP conducted the first ever public forum in search of the next Chief Justice. And former Supreme Court Justice Maria Alicia Austria Martinez believed that it will take time before an outsider gets to understand and appreciate the judiciary as well. As an outsider, Dean Bautista, do you believe that you have a distinct disadvantage if you become Chief Justice, since it will require a longer time for adjustment than those you have that could have been appointed from the inside? If not, can you convince us that an outsider like you, without judicial experience, would be able to accomplish your role as Chief Justice, pursue judicial reforms, and administer, of course, the judiciary in the most efficient fashion?
To answer that question, Undersecretary Muskie, I think that the question all of us need to ask is that, are we happy with the way things are? Because if we're happy, then we should have more of the same. And I think that is where I am coming from, that there has to be a recognition that there is a problem, in which case perhaps we need a radical, out-of-the-box solution. Bringing in an outsider will hopefully provide new ideas, new perspectives, new insights in the way the court can function. As I said, we can bring in initiatives, not only from other countries, but also from the private sector to help in the system. As I said, part of the problem, I think, is that the courts of the past have been reluctant to accept constructive criticism. They have been reluctant to work with other stakeholders. I think that has to be changed. As I said, things are changing. We look at the 1987 Constitution. When that was passed, at that time, there was no cell phone, no internet, cable. There were only 5 channels, I think. 25 years later, our lives have changed. I think that the court should also change hand in hand with what is going on in society. So, to my mind, an outsider can provide a breath of fresh air into the workings of the court.
Dean Andy, how many cases are pending before the Supreme Court for or in behalf, for or in against the PCGG, do you think?
65 po.
And how do you think that you will maintain your integrity, your probity and independence as a PCGG commissioner right now and after you become Chief Justice, God willing?
I will inhibit po from the PCGG cases.
Do you think that matter of inhibition is sufficient to address judicial independence then?
Well, to be honest though, I would think, that just because I was PCGG chairman should not automatically mean that I should inhibit. But again, if you look at it, and so as to dispel any doubts or to dispel any accusations of partiality, perhaps the more prudent action would be to inhibit if and when those cases are heard.
One final question, Chairman. You mentioned that during the Marcos administration, the court was timid. However, now that it has become aggressive and sort of an activist, could you cite at least 3 decided cases where you think that the Supreme Court has overreached and perhaps violated the political question doctrine?
Top on my list is the Manila Prince Hotel case, wherein a Malaysian investor won the bid in a closed bidding, but the Supreme Court overruled the bidding and awarded the case to a Filipino group, saying that, again, a apparently under the Constitution, in terms of properties that have a national or historical significance, that these should belong, that they form part of the national patrimony and therefore should belong to Filipinos. Of course, we all know that even if Malaysians own the Manila Hotel, they cannot bring Manila Hotel out of the Philippines. Second, there was that case of Garcia versus Board of Investments. Okay, this is a case involving a petrochemical plant wherein the investor wanted to move their investment from Bataan to Batangas. But the governor of Bataan did not want such a move because it would impact the revenues of the province. The Supreme Court again interfered with the decision of the investor and allowed granted the petition of the province of Bataan and therefore was able to stop this investment from happening, in which case, instead of the Philippines being able to attract that investment, this investment went elsewhere. And again, also with respect to some of the political cases, for example, the case of Estrada versus Arroyo, I wouldn't have decided it that way, in the sense that that to me was a classic political question doctrine case. Why are we going to force the issue as to whether or not President Estrada resigned? To my mind, as far as I'm concerned, at that point in time when the court was called to make that decision, he was no longer in power. The cabinet already had abandoned him. The diplomatic corps already recognized a new president. Why does it have to be that the court has to go and sort of like decide on merits and sort of like try to argue that there was indeed a resignation when the person himself said, no, I did not resign? So there are certain cases wherein I think it is better if the Supreme Court should take a back step and just allow things to happen as they are. They should not see themselves as the solvers of all the nation's problems, because that is not the case. And as I said also, I think they have to recognize their role, given that, again, within the scheme of things in a democracy, elected representatives are of a higher status than unelected representatives.
And that will be all for the aspirant. Mr. Chairman, thank you, Andy. Good luck.
Thank you also, Secretary. Now, Congressman Tupas will now have the floor.
Thank you very much, Mr. Presiding Officer, Justice Peralta. Good morning, Dean Andy.
Good morning.
Kanina natanong na yung gusto ko itanong yung age, diba? Kasi nakikita ko dito 48 years old. Lang kayo po, no? Batang-bata.
Pero mas bata po kayo sa akin.
Mas bata ako. Pero kanina nasagot nyo na raw, ang sagot nyo ay age doesn't matter. Diba?
Tsaka ang sinabi ko rin po, dapat may term limit. Pati sa judiciary. In the same way, may term limit sa executive at legislative, dapat may term limit na rin ang judiciary.
Meron nga 70 years old.
Hindi, ang sinasabi ko po, 7 and 70. You only serve, because if you look at our constitutional commissions, COA, Civil Service, COMELEC, 7 years, tama na po yun.
Pero hindi kasi mangyayari yun ngayon At this time, hindi mangyayari yung term limit pag ikaw yung ngayon, nagde-deliberate tayo. So ang question ko lang.
Sinabi ko rin po, ako'y handang mag-sign ng waiver.
Ilang tao? 7 years lang?
7 years lang. Tama na po yun.
Okay. Pero 7 years, matagal rin yun. Kasi considering na may mga justices tayo incumbent ngayon, na 2 years na lang magre-retire sila. Diba? Yung iba 4 years. At tinatanong ko lang ito because I think para sa akin, siguro yung ibang members rin, parang naging open ngayon yung proseso sa outsider. Ngayon, meron na pagkakataon yung outsider. For a long time, parang seniority yung tinitingnan. Pero because of anong nangyari, tinitingnan na rin ngayon yung outsider. At least ako, tinitingnan ko yon. So, yung age naman na 48 years old, kahit pagpalagay natin 7 years mag-waiver, mag-sign ho kayo ng waiver, assuming na gagawin nyo yun, matagal pa rin ho yun. At mababypass yung iilan. Kasi alam naman natin And I am sure, tao lang naman yung mga ito Di ba may pangarap rin at saka ang iba naman gusto rin mag-Chief Justice kasi gusto rin makatulong sa ating bayan. So, paano mo nakikita ito, assuming na ikaw nga yung ma-appoint, no? And youngest Chief Justice. And kahit hindi 22 years kayo mag-serve, pero 7 years lang. Paano nyo i-unify yung Korte Suprema? Especially yung mga senior doon na yung masasapawan sila. So, yun lang, very short, I just need very short answer to that.
Well, tama po yun. No? At sinabi ko nga kanina po na sa aking palagay, all things being equal, dapat insider over outsider. Except that we are in a peculiar situation. Alam niyo po kasi nga, kung ikaw papasok, at nangyari na po ito sa aking mga ibang naging trabaho, kumbaga, kailangan nga medyo sensitive ka sa mga ganitong klaseng issue. So you really have to earn the trust and the respect of these people. Pero dapat din po nilang ma-realize na kumbaga meron tayong constitutional framework at meron tayong rules and regulations. Kung itong taong ito ang nahirang ng Pangulo dahil sa listahang naibigay ng JBC, kailangan po yung respetuhin.
Ang tingin mo may unify mo rin pa rin yung... Kasi what we need now is yung parang figure na may status na stature na mag-unify ng Korte Suprema. Tingin mo ikaw yun?
Well, sa akin po palagay na kaya po, no? As long as people, I think, are professional in the way they deal with things, as long as people, again, look at the big picture and the collective interest of the common good, there should be no problem.
Okay. Pangalawang question ko. Balikan natin yung nangyari kasi kung wala naman yung impeachment, wala tayo dito ngayon, tsaka hindi ka rin aplikante, no? Hindi ka mabibigyan ng pagkakataon. Yung prosesong yon, tingin mo healthy yon personally? Healthy yon sa hudikatura?
Opo.
Bakit?
Kasi nga po, I think that focuses, nasabi ko rin kanina, no? Sa akin palagay po, yung impeachment ni Chief Justice was not just an impeachment of a person, but the impeachment of the system. Na, kumbaga talagang kung magtatanong ka sa mga karaniwang tao, meron silang pag-aalinlangan laban sa ating sistema ng katarungan. Kung kaya talagang dapat magpasok ng reforma. Kaya sa akin palagay, yung pag-impeach sa kanya, unang hakbang lang yan. Marami pang dapat gawin.
So healthy yon sa system?
Healthy po yun.
Punta natin yung transparency at saka yung degree of criticism kasi kanina nabanggit nyo yun Kasi tayo lahat, mga abogado tayo, di ba? Yung Pangulo, for example, executive, kahit i-criticize natin ang todo-todo yan, okay lang, di ba? Elected yan. Kami naman sa Kongreso, binabanatan rin kami. Sobra-sobra rin, pero okay lang sa amin. Di ba? Pero pag criticize mo na, for example, yung korte, yung judge, or Korte Suprema, maraming kaso na nadidisbar ka, na kukontempt ka. No? So, parang sa ibang tao, hindi sa akin, sa ibang tao, parang sinasabi nila, yung sistemang ito ng the three branches of government, yung may tendency ng pag-autocratic, out of the three, yun pa yung hindi elected branch of government, but appointive. Because of the cases na nangyayari nga na to. Disbarment, konti lang, kaya yung iba takot Diba? Marami talagang takot sa mag-criticize sa Korte Suprema. Kaya nga, noong una nga, di ba, kami lang yung kasama doon sa impeachment, wala namang talagang nag-risk doon So, pag ikaw na, for example, ang naging Chief Justice ng Korte Suprema, ano yung specific reform, no? Towards dun sa degree of criticism? Because, Republican system Di ba Republican tayo, representative yung tao, sovereignty resides in the people and all government authority emanates from them. Hindi naman talaga dun pa rin pupunta At yung tao, may certain degree of criticism tayo, may transparency. Gusto ko lang, very, very briefly lang, ano yung specific mong naiisip na i-reform yung sistemang ito if you become Chief Justice?
Mr. Representative, the word that comes to mind is balance. We have again to strike the right balance. On the one hand, there are your rights of free expression. Okay? And I think these are sacred rights. In a democracy, these are the rights that fuel thought and innovation. On the other hand, though, there is also the right naman of the court to maintain its integrity, credibility, its authority to dispense justice. we have to strike a balance between the two.
Paano yan? Paano mo
I
gagawin?
think dapat yung criticism is constructive, hindi personalan. Yun ang nagiging problema minsan. Kaya for example nga ako, sa aking mga column, as much as possible, ayokong yung mga tao, because to me we should focus on issues as opposed to focusing on personalities. Itong mga desisyon na ginagawa, okay, tingnan lang natin on the merits, okay, on the issues being raised.
So, magiging mahabang pasensya mo, ibig sabihin.
Yes, I think
Pag
that
ikaw ang naging Chief Justice.
dapat lang.
Okay.
You know, in a democracy, dapat ganyan.
Okay, so last, siguro 2 questions na lang, Mr. Chairman. Yung, nabanggit mo yung expanded jurisdiction at parang hindi ka atas ang ayon dun sa nangihimasok sometimes, sabi mo, ang Korte Suprema sa political questions na traditionally. Gusto ko lang tanongin sa iyo, di ba, nakalagay yung expanded jurisdiction, yung para section 8, paragraph 1, yung expanded jurisdiction, no, ng Korte Suprema. Tingnan nga natin, di ba nakalagay doon na yung grave abuse of discretion? Diba? Tapos let's say, meron naman sa Constitution, on the same Constitution, nakalagay naman na sole judge. Like for example, yung House Electoral Tribunal, diba? At yung Senate Electoral Tribunal. Di ba merong term yon sa Constitution na sila yung sole judge with respect to qualifications ng mga congressmen at senador. On the other hand, ito naman expanded jurisdiction. No? Section 1, paragraph 2, paragraph 1 or 2, but expanded jurisdiction. Nakalagay, parang ito naman general. No? Paano mo i-reconcile yun? Let's say, kasi ngayon, ako, nung nag-aaral ho tayo sa UP at ng law, yung kala namin yung sole, pag House Electoral Tribunal, siya talaga yung sole. Diba? Pero ngayon, because of, may mga cases na pumasok na yung Supreme Court. So very briefly lang, paano mo i-interpret or reconcile yun?
Well, ito nga po yung mga ehemplo ng mga parang inconsistencies ng ating saligang batas na dapat i-cure, no? Pero sa akin pong palagay, ang issue is it really a legal matter? No? Dito po, sa aking palagay, even if nakalagay na sole, I think it is a matter that the court can take cognizance of because it pertains to legal issues.
So,
at I try to distinguish that from cases that have a lot of economic and financial
no, ibig sabihin, kahit sole yan, sole judge on qualifications of members, tapos pwede pumasok ang Korte Suprema.
Again, sabi nyo nga, dahil sa Article 8, Section 1, itong grave abuse, pursuant to Rule 65, they have the ultimate power to determine whether or not there has been grave abuse. And this is different from the power of judicial review. Kaya masasabi nyo po, yung Korte Suprema natin, mas malakas sa Korte Suprema ng Estados Unidos.
Okay, last question. Dahil dito sa impeachment ng dating Chief Justice, parang ang taas na ng standard, di ba? Kahit ngayon, dati hindi naman ito tiniterevise eh. Ngayon, terevise tayo. Yung tao, ibig sabihin, tumututok, di ba, sa atin. Tumututok sa atin, sa lahat na to. At may pagbabago, di ba? Kanina, although hindi naman ako sang-ayon sa inyo, yung sinabi niyo yung Kongreso, na parang nag-aalang-langan yung tao sa Kongreso, no? Although ako, Constitutional Convention ako, hindi ako Constituent Assembly. Pero hindi ako sang-ayon sa sinabi niyo. Pero since nagbigay na rin kayo ng opinion niyo sa Kongreso, tatanungin na rin kita. Kahit alam namin yung impeachable, kami ang magde-decide, di ba, ang Kongreso. Dahil sa napakataas na standard, tingin mo ang plagiarism ba impeachable?
Mahirap pala dito, Justice.
Sabi mo kanina, estudyante ka eh.
Oh. You know, if ako feeling ko nga, you know, you being a aspirant, you are like a binibining Pilipinas contestant, a witness in a Senate hearing, and the lawyer in the impeachment trial, all rolled into one.
Pero sagutin mo na.
Again, kasi po sa akin din naman palagay, okay, we have to take into account the circumstances in respect of the case, no? Na, kumbaga,
Per se,
okay.
plagiarism, nag-plagiarize ka. Per se, hindi, saka na natin pag-usapan pa yung ibang detalye.
Yes,
plagiarism itself.
We have to look at intent. We have to look at circumstances. Again, if you have to be very specific about the case that I think you are referring to, I would probably say that it is not, given the circumstances that I know about that case.
Okay. Thank you, Mr. Chairman. Thank you, Dean.
Now it's my turn. No? Naniniwala ka rin naman, Dean Bautista, na yung kasalanan ng isa ay hindi kasalanan ng iba. We are clear on that.
Tama po yun. Parang po yung mga kasalanan ng ama, hindi po kasalanan ng mga anak.
Okay. Thank you. Now, you were talking about an anecdote. No? You asked 40 students of yours that, who would like to join the judiciary, who want to become judges, and you said that only 2 responded. And one said that he or he wants to be justice of the Supreme Court. Is that my daughter?
Hindi po.
It's not my daughter. Definitely not my daughter. He's a professor of my daughter in Ateneo. Now, I have another question. Particularly Article 12, Section 5, Paragraph 5, the rulemaking power of the Supreme Court.
Article 8.
Article 8, Section 5, Paragraph 5. The Supreme Court has the power to promulgate rules and regulations in the enforcement and protection of constitutional rights. And that they say that the Supreme Court has become aggressive also because of this provision, and it has become powerful because of this provision. Now, if there is charter change, you would like that this provision be surrendered and amended to exclude this particular provision if there is a constitutional change?
No, I don't, Justice. Because I think in the end, with respect to rules of procedure, with respect to the practice of law, the Supreme Court would still be in the best position to make those rules.
Okay.
Ako, ang aking feeling po dito is that the people who are on the ground should be empowered as much as possible because they know the problems. So, ang issue lang po dyan, and again, I think Father Bernas raised this before, yung bang poder or kapangyarihan ng ating Korte Suprema, is that concurrent with the power of Congress?
That was supposed to be my next question,
Oh.
if that is concurrent. Because my next question is this, no? There is a conflict between the authority of Congress to fix filing fees and other court fees with that of the provision of the Constitution, this particularly because the Constitution likewise allow the Supreme Court to promulgate rules in the practice of law. And therefore, it can fix the filing fees and other court fees. And in fact, those are provided for in Rule 141 of the Rules of Court. So if there is a law passed exempting a certain public institution in the payment of filing fees, and the Supreme Court insists that the power to exempt the filing of fee belongs to the Supreme Court, if you are not the Chief Justice, how will you resolve that?
Pagka ganun po, I think that Congress should be differential in so far as rules concerning practice, pleading, and procedure. Yes, there is nga that debate as to whether or not they have concurrent power. I think that although in fairness to Congress, they have not really passed any law that would try and go against that power of the court. And perhaps they also realize that in case they do that, baka matalo sila kasi the final say in respect of the interpretation of the Constitution lies with the court. So siguro pwede natin gawin, if we do go through a constitutional amendment, lagyan natin ng word solely. Solely has the power to promulgate rules regarding practice and procedure. Bibigay lang natin sa Supreme Court.
What about the rulemaking power of the Supreme Court? Is that not in conflict with Congress? For example, let us take the case of writ of amparo.
Yeah.
That writ of amparo actually is a product of the rulemaking power of the Supreme Court. In fact, some say that what Congress failed to do, the Supreme Court was able to do it. We resolved the problem of involuntary disappearances. Take that as a sample. Supposing somebody will challenge the promulgation of the rule on writ of amparo, what will be your position?
Again, here, ang aking feeling is that in so far as it tries to implement this constitutional directive to promulgate rules regarding the enforcement of constitutional rights, kumbaga, sakto po yan sa isang probisyon sa ating saligang batas. In which case, sa aking palagay, maliwanag po.
So papayag ka ron
Papayag po ako na yun.
Nandun pa rin.
Na nasa Korte Suprema
Ang
po
hindi
yun.
mo pinapayagan, yung Section 1 of Article 8.
Yan.
Yung
pong-
power of
yung
the court.
pangalawa.
Oo,
Hindi yung settle actual controversy.
because that provision might tackle political issues, and political issues are not within the province of the Supreme Court.
Well, purely political, yes.
Yeah, that's correct. Okay.
That's right.
Now, you were also suggesting that in order to reduce the backlog of cases, there is a need to amend Article 8, Section 12, or Section 15, I think.
15.
The periods required of the courts to promulgate their decisions. No? But are you aware that the Supreme Court now has promulgated rules of procedures that reduce the periods within which to promulgate cases? I cite you examples like the rule and summary procedure. It is only 1 month, whereas the Constitution provides that insofar as lower courts are concerned, they have 3 months. You have the rule of procedure for environmental law, where the Supreme Court promulgated rules that it needs only 1 month. No, the courts have to promulgate their decisions within a 1 month period. Now, also in intellectual property cases, we just promulgate the rules on intellectual property. We have likewise limited the period within which to promulgate within a period of 1 month. So do you think that there's still a need to amend Section 15 of Article 8? Anyway, there is a collateral and the provision unless reduced by the Supreme Court. How are you going to respond to that question?
Mr. Justice, first of all, I think these are all steps in the right direction. And we have to applaud and we have to encourage the Supreme Court in doing these kinds of rules. No? Pero ang aking pong punteriya dito talaga is that, kasi nga, dahil yung period is counted from the date of submission as opposed to the date of the filing. Tinitignan ko po yung mga kaso po ng PCGG. Karamihan po dito, final 1987. 25 years na, nakabinbin pa po sa mga korte. In fact, meron pong mga ibang kaso, hindi pa po nagsisimula yung trial.
But in these PCCG cases, if you go over the petitions that were filed in 87, you will find that there were a lot of petitions or motions to amend the complaints. The cause probably was not attributable to the courts. It might have been could be attributable to the petitioners themselves, the government, the OSG, and also the lawyers of the other parties. Because considering the number of defendants, the number of intervenors, the number of third-party complaints, and so on. You should not.
Tama po yan. Again, in fairness talaga nga, I'm not trying to single out, kumbaga, the court as the culprit. But what I'm saying is that the stakeholders, the participants in our justice system are there to blame. And it includes PCGG itself.
Yeah, that's correct. Yeah, the way I was observing you, when you were asked by Justice Hermosissima, your answers were tend to invite or to court the vote of Justice Purissima. when you were asked by Congressman Tupas, your answers were also intended to court the vote of Justice Tupas. Now that I'm propounding the question, you're trying to court the vote of the Supreme Court. Huh? Is my observation correct? So anyway, let's go to Rule 65. Let's go to Rule 65. According to you, Rule 65 is a culprit, is a cause of backlog. Are you aware that in 2007, I think, we amended Rule 65? We put a limit to the period as to when a petition for certiorari under Rule 65 be filed. Before it was within a reasonable time. Now we fix the period at 60 days. And that if there is an application for a restraining order, and there is no restraining order that be issued within the 10-day period from the filing of the petition, then the lower court shall proceed with the case, even if the main petition is not yet resolved by the appellate court or the Supreme Court for that matter. Are you aware of that?
Yes, I am, Justice. And again, this is, I think, a step in the right direction.
Oh,
pero sa aking palagay po,
that's another vote?
Hindi, pero now I will lose the vote. Kasi po sa aking palagay, kulang pa eh.
Kulang pa ba?
Kasi inaabuso po yung Rule 65. Alam mo, pagka yung maliit na motion, maliit na incident, i-appeal. Interlocutory appeal, Because of that,
Oh,
matatagal.
yeah.
Alam niyo po, ang gusto ko sana like this. Para pong sa tennis ngayon, hindi ba po meron silang replay?
Tinignan mo na naman si
Si
Justice
Judge
Hermosissima
Hermosissima,
kasi
opo.
he plays tennis.
Yun na nga po. Hindi ba meron sila ngayon po yung replay na you can question the decision of the umpire, I think 3 times only. But kailangan merong limit eh. Hindi pwedeng lahat ng incident pwede mong iakyat.
Yeah, but
So you have to also choose.
You know what we are doing in the Supreme Court? If a petition, a new petition is filed before the Supreme Court, if it is Rule 60 or Rule 45, that means is a question of law and raises a question of fact, we can immediately dismiss the case on the ground that the questions raised are questions of fact. There is even no need of requiring the other party to comment. Now, if it is a Rule 65 as a special civil action, a petition for certiorari, and there's really no ground for the issuance of a TRO, we can also dismiss the petition. And that's what I've been doing, Dean Andy. Are you aware of that?
Yes, in fact,
you're
we
aware.
know you are the authority po in criminal procedure.
No,
At sana po
I'm not.
magturo ulit kayo.
Ang problema, ayaw ng misis natin. So, okay, anyway, last question. No? This is an observation only of your comment on the Supreme Court has no work plans to speak of. I hope I did not get you correctly, no? Baka you might lose your vote. Yeah, for your information, we have several committees, no, formed by the Supreme Court, and these committees are headed by a Supreme Court justice, no. We have a committee to undertake the study of how to resolve the backlog of cases in the lower courts. We have the Committee on Computerization undertaking the study as to whether we can computerize all courts, including the first-level courts. And I do not know if you read the speech of our Senior Justice Carpio, that computerization has been effective in the Court of Appeals, and we want to introduce the system in other courts. And then we have also the PMO, which is the Program Management Office that undertakes the management programs of the court, headed by Justice De Castro. And then we have also the Mother Rule Committee, what we call the committee that undertakes the revision of the rules of court, which we call the Bible of all courts. And we have several committees to undertake and to answer the concerns of like you. And we discuss them on a regular manner. What happened to the meetings conducted by the committees. And in fact, we invite members of the IBP to join us in the committees. We invite NGOs to join the committees. We invite our developmental partners, no? I think Attorney Masguera is here. He was one of the, I think he's in the audience. He used to be a part of the ABA, I think, yeah. That also helped the Supreme Court in its program. And I just want to tell you this, that this is what we are doing, you know, to improve the efficiency and effectiveness of the Supreme Court. Now,
Sorry,
lastly,
Mr. Justice, if I can just say, again, I am fully aware of these programs. I think these programs should be encouraged. Siguro ang dapat lang talaga, the court should communicate these
Ang
matters
problema-
more to the public.
ang problema namin hindi kami kasi politician, with due respect to Congressman Tupas, hindi kami pwedeng magpa-interview sa TV regardless of your physical appearance. Hindi po kami pwede.
Hindi,
We
pero
just-
hindi naman po kailangan magpa-interview. Alam nyo, yung sa website, there are so many social media now that are available. Meron naman po tayong press spokesman. Just update regularly the public on what the court is doing to try and fix the problems.
We have actually the PIO, but with limited resources now. You can just imagine inside the court here, the session room, we have to borrow the television equipment of Channel 4 so that you can be seen before the eyes of the public. And therefore, that is my last question, my last comment, dear Dean Andy. I think we are through so far as you are concerned.
Ay, maraming salamat po sa
Maraming
sa
salamat
mga
din.
miyembro ng ating council. if I may just circle back to what I first said, no, that as far as I'm concerned, really, while choosing the next Chief Justice is very important, we should not lose sight of the larger objective, which is to overhaul our justice system. And also, one person cannot do the job. It is a complex problem. I wish that the court, the JBC, the key to me is forming a justice league or a group of legal avengers that can really go through and really slay this problem that are facing our judicial system. Maraming salamat po at magandang umaga.
Maraming salamat din.
Your Honors, the next candidate to be interviewed is Attorney Soledad Cagampang de Castro, Consultant of Counsel of De Castro Cagampang de Castro Law Office.
You may take your seat now, ma'am. Are you ready now, ma'am?
Yes, I'm ready.
Okay. Attorney Cayusa will first ask the questions.
Thank you, Mr. Chairman. Good morning, ma'am. Attorney De Castro, your records will show that you were nominated by among others your own son. Yes. And with some other individuals. Yes. And in the light of the recent impeachment experience, why did you decide to accept your nomination to the Supreme Court?
I thought the JBC should have some alternatives rather than just be limited to people who are already known, publicly known because they're already public officers. I thought the JBC should be able to look beyond who are already in office. Maybe the private sector may have an alternative also.
Ma'am, may I just know if your husband is supporting you on this endeavor?
You know, there are many lawyers in the family. I grew up with a family of lawyers, so I'm used to as many opinions as many lawyers around.
Because what makes your circumstance rather distinct is that your husband has also nominated others to the position and in fact has invoked the equity of the next in rank.
Yes, I know. And I respect his opinion.
What to you is the experience that you have as a private practitioner, which would give you a distinct advantage to the nomination?
I think as a practicing attorney for so many years, we have borne, among others, we have borne the brunt of the difficulties confronted by private practitioners because of how the judiciary operates. So while we are not within the organization, we are the quote-unquote victims of whatever anomalies or inefficiencies in the system. And I think an outsider looking in can have a contribution to have a more efficient judiciary.
What have you accomplished in the past that would convince us that you have the qualities needed in order to bring about an improvement in the administration of justice?
Well, I have been in management, although it is in a private enterprise. I was the head of an executive vice president for legal and audit in what used to be the biggest mining company in the Philippines for 16 years. And then I was able to put up a newly created office in the Office of the President and made it operational in 1 year from scratch. And so I have an idea of how a government office should work or ought to work, and how in private enterprise, I think the principles of management would be more or less the same as in public offices also. And maybe I could contribute a little bit of that experience.
But you admit that the question of the administration of justice is more than just a business enterprise. It's more complex.
Of course.
And do you think that you have the capabilities to address all the concern, given that you have never had any experience in the judiciary?
In terms of management and administration, I think my experience in management could help me out in that. If as from my information, there are about 22,000 employees in the judiciary from top to bottom, and 2,000 of which 2,000 are judges or actually doing the work of judges. It's really not that much.
Thank you, Attorney De Castro. Now moving on, you mentioned that you have been working with the mining sector. Do you believe that the court has overstretched its mandate when it implemented rules that pertain to particularly the writ of kalikasan? What are your views on this?
The writ of kalikasan is also an implementation of a constitutional policy to protect the environment for future generations, as laid down in the principle of in its decision in the Oposa case. And I think the role of the Supreme Court in terms of protecting the environment should be retained and actively pursued.
Thank you, ma'am. My final question. What is your judicial philosophy on gender equality and gender discrimination? And do you think that our courts have been able to achieve gender equality now?
I think still trying. But you know, I grew up in an environment where there was no gender equality. My mother was not allowed to go to college because my grandfather believed that only guys or his boys could go to college. So I grew up in an environment where my mother insisted that her daughter should have equal rights as her sons. So that's how I came to be what I am now. So I am for gender equality, but in my experience, there's always a glass ceiling for women. Whether you like it or not, it appears invisible until you're on that particular level when you have to go to the top. And I think this is also one of my objectives, to find out whether in the judiciary there is also that glass ceiling that is invisible.
Could you be more specific as how you could promote, how you expect to promote gender equality in the event that you become Chief Justice?
All applicants for the judiciary should be equally evaluated. They should undergo the same rigors of application, interviews, and credit and background checking, all the same. No discrimination whatsoever. Because the way, from my personal experience, I made it a point that nobody should carry my bag just because I'm a woman. I should walk like the other men when they go to work. No special treatment, because that is the cost of equality.
And I'm sure you look forward to the day that we would have a lady Chief Justice. With that, ma'am, I end my questions. Mr. Chairman, I have no further questions. Thank you.
Attorney Mejia.
Thank you, Mr. Chairman. Good morning, Attorney Kagampang De Castro.
Good morning.
Mayroon po tayong note dito na may mga humihiling na itanong yung ibang katanungan sa Tagalog para maintindihan daw ng ordinaryong mamamayan. Pipilitin po namin.
May note lang ako ay Bisaya, ha?
Pwede rin po siguro sa Bisaya.
Sige.
Okay.
Halo-halo.
Ugnay po, no? Or I would like to take off from where Attorney Cayosa left off, gusto ko rin pong itanong, pinag-uusapan po kanina yung gender sensitivity. Kailangan po ba magkaroon talaga ng gender perspective o pananaw sa kasarian o may kaugnayan sa kasarian, gender perspective in deciding cases? Should there really be a gender perspective in deciding cases, to your mind po?
Ang ibig sabihin, kesyo ang litigant ay babae, iiba ang view mo. Siguro, in a sense, when it involves sex crimes maybe, or violence against women. Pero in other aspects, dapat pareho lang. Kesyo babae, pareho mang emotions yan eh. Pareho namang problema niyan eh. Parehong nagagalit, parehong umiiyak. Pero kung crimes against women, siyempre iba yun.
Thank you po. Attorney Cagampang de Castro, should you be appointed as Chief Justice? No? Kung kayo po ay mahihirang bilang punong mahistrado, mayroon na lamang pong malalabing 3 taon upang kayo ay magsilbi bilang Chief Justice. No? There will only be 3 years for you to serve as Chief Justice. How do you intend to make an impact within those 3 years that will be left for you to serve po?
It means I will just work double time, meaning instead of reviewing the entire organization for maybe a year, I'll do it in 3 to 6 months by inviting expert consultants. I will abbreviate the processes, the preparatory processes, so that if there's any change or reform that is needed or improvement that is needed, it could be implemented as soon as possible.
How will you characterize the level of corruption po, or the perceived corruption in the judiciary, and what will you do to address it?
Of course, I am an outsider, and as you said, these are only perceptions because it's very difficult to establish. But we just hear it from complaints of clients or from party litigants, not your clients, and even fellow lawyers. They complain about this or that. And I think the problem of corruption has been there with us for ages. And we need a long-term solution to that. And I think I could start now. I have been an educator for, at least in law school, for 11 years. And after that stint in UP for 11 years, I've been teaching in almost all the other downtown law schools, out of curiosity, really, because I wanted to know what quality of education, legal education, is there outside of the more famous schools. And I thought that there is a need to go back to the teaching or imbibing of values, especially for lawyers. Now, the problem with many lawyers that are not full-time students or who were not full-time students, that they come from work, they go to their classes unprepared, and they don't have the preparedness for law school. Because every time I ask a question, it's very difficult for them to comprehend. Either they lack the proficiency in English, they don't understand, or they're simply unprepared, or their pre-law preparation has been quite inadequate. I was so surprised because I was brought up in the humanities. I had an AB with all the humanities, so we had ethics, we had logic, and then we had philosophy. But many of these law students now, especially the working ones, they have already their own careers. And you find out that they are professionals in their own right, but they did never have logic or ethics and philosophy. So these are the basic values, the subjects that imbibe, that teach you the values to be good lawyers. So maybe if from the outset we prescribe, the Supreme Court to prescribe that to be able to qualify for law school, you should have taken all the subjects, some humanities subjects, then that's already a step forward to improving our law students and eventually lawyers. This is the value system. And then we should have continuing training in law school in ethics. Just don't relegate ethics into the background. 1 unit on the last semester of law school, as if it is really nothing. And then in the bar subjects, in the bar exam, it's combined with legal forms. I mean, what kind of message do you put on the importance of ethics? Practically nothing. It's with legal forms. And so maybe if you revise a little bit the law curriculum as well as the pre-law admission requirement to law school, wherein you put in the element of the ethical conduct of lawyers to be, or simply human beings. Maybe we could improve on the long term, of course. This is a long term, the effect of that is long term. In the same way that corruption has been a long term problem in this country. So maybe we could start with that. That is from the field of education, of course.
Thank you po. That's my final question, and thank you, Mr. Chair. Thank you po, Attorney Kagambang.
Justice Lagman.
Thank you very much, Mr. Chair. Attorney De Castro, good morning.
Thank you.
I was reading your personal data sheet, and I noticed that you are 67 years old.
Yes.
Now, I also noticed in your data sheet that from 2000, you were an active partner in your law office before, up to 2011.
Yes.
Is that right?
Mm-hmm.
And starting last year, it is indicated here that you are now the consultant or of counsel
Yes.
of
The same law firm?
the same
Yeah.
law firm.
Actually, it's the same law firm.
Meaning,
Mhm.
I interpret it that you are now
Retired, more or less.
not
It's
exactly
really-
semi-retired, but you are taking a less active role
Yes.
in your law office.
Mhm.
So I am just wondering, what motivated you to apply for the post of Chief Justice, considering that this position entails not only that this position is a is not only a full-time job, but a back-breaking job as well.
At 67, I have only 3 years.
Yes.
To 70.
Yes.
It's never too late to do something
Yes,
substantial.
I agree with you. But my worry is that, how about your health? Can you handle the full-time job of a Chief Justice? You have to go to the office every day, from morning up to late evening, and you have to not only to attend to the cases assigned to you, raffled to you, but you have to be the chief executive officer of the court.
Yes,
So,
I know.
Something like that. So it's a full-time job, and I'm just wondering, you are now, for 1 year, your role in your law office is, I think, it's a part-time.
Yes, basically I've been involved I have 2 books in line, so I still work up to the wee hours
But in
of
the-
the evening
I
on
think
my own time.
In your
That's
own
the
time
difference.
and in the house.
Yes.
If you want to relax, you can relax anytime.
That's
but as
right.
the Chief Justice, even if you want to relax, you cannot relax because of the volume of your work.
Yes,
So
that's
do you
right.
think you can handle that?
I think so.
How is your health, Attorney De Castro?
I think I have a medical I have undergone medical examination, and if I believe the doctors,
Yeah, what did they say?
they say I'm fit to work. So, because actually I was really waiting for the medical exam, because if the results would say not fit to work, then I would probably just, stay put.
Okay, so did you tell the doctor that you are applying for the post of Chief Justice?
I didn't have to tell them.
But
I think they're ready.
You will just use that certificate for purposes of...
No, they didn't know that.
I see.
Actually, there are 3 pages in my laboratory.
Oh, yeah.
Instead of just 1 page, I said everything. So in Makati Med, they called it 23 something. So
Yes.
it's all the works.
So,
I wanted to be sure because, I have to be fair to you.
yes. And to
I have
yourself
to-
also. And to your family.
Yes. I have to be fair.
Okay. So on that note, I have no more question for Attorney De Castro. Thank you very
Thank
much,
you,
Attorney
thank
De
you.
Castro. Good luck.
Justice Hermosissima, sir.
Good morning,
Good morning.
Professor. Are you familiar with the writ of Kalikasan, the writ of Amparo?
Yes, the writ of kalikasan refers to you can apply for it if you want somebody to stop damaging the environment. I think that's what they resorted to in Zamboanga to stop mining there. And then the writ of amparo is if somebody is lost or you suspect of being taken by the military, it's almost like it's a relative of the writ of habeas corpus.
On what basis did the Supreme Court promulgate and issue these writs? Or would you rather have these writs passed in Congress?
No, I think it's in the proper place in the Supreme Court. To me, it's like an emergency situation when you resort to these writs. And if you have to wait for Congress, I think many people have to deliberate on it, and it will take time.
Could the unmitigated proliferation of deaths caused by violence of judges, journalists, and other private individuals, are you in favor of the revival of the death penalty law?
I think if you have a criminal committing such heinous crimes, death is too merciful for him. I think a life sentence would be better, so he could really feel how it is. Death would be, would say, there is a prayer about death. It's a release. Death is a release from all the travails of this life.
Anyway, do you believe that the extreme penalty of death is a deterrent to the commission of such crimes as murder, parricide, rape, and kidnapping?
Not necessarily, because for a long time this has been an issue whether death penalty should be adopted or done away with. And from my personal point of view, it's only the Creator that created life that could take away life. And from the pragmatic point of view, making a criminal suffer in prison would be a better alternative than death.
Will you not change your mind if you consider the fact that quite recently the Federal Supreme Court of the United States upheld the constitutionality of the death penalty? This in spite of the opposition of American bishops to the imposition of the penalty of death. 4 Catholics in the court voted in favor of the imposition of the death penalty.
Maybe,
What do you say?
maybe they affirmed that they are in favor of the death penalty under the particular circumstances of their society. Because maybe in U.S. society it's now quite difficult to control, considering the freedom, the extreme freedom that people are allowed to exercise, and are very difficult to control. Maybe that's the reason for their change of heart with respect to death penalty.
That will be all.
Thank
Mr. Chief. Thank you.
Congressman Topas will no longer ask question. It's now the turn of Secretary Mosngi.
Thank you, Chair. I think my questions have already been propounded. I am satisfied with the answers. I have already enough to form an opinion. I give it to the Chair, Mr. Chair.
Okay, Attorney De Castro, what is your inclination? Resolve the issue for the common good, or resolve the issue in favor of what you know and believe is just and right? Is it between common good or just and right? What is your inclination?
You know, if you're in the judiciary, your task is to dispense justice, and justice is supposed to be blind. The question of common good is a pronouncement of policy. And if you're in the judiciary, your task is not to pronounce policy, but to distribute or dispense justice. You have a rule of law, you have a set of facts, then you decide what rule will apply to a set of facts. But for the question of common good, although it's also used in our Constitution, it's a question of, the issue is policy. It's more addressed to the legislators, because they will have to determine whether something that they will adopt as law is for the common good. So I think in our system of government, where there are different branches of government, they have specific spheres of authority and power. The judiciary's task is to dispense justice.
Okay. Now, aside from the qualifications, general qualifications provided in the Constitution, independence, probity, integrity, and probity and integrity, no? Are there other independence? Are there other traits and virtues that a candidate should possess in order to be an effective Chief Justice?
I think that Chief Justice should also be humane, because he or she is not only a dispenser of justice, but being a head of office, he or she has to be an administrator. And you know, you have employees, justices are also people, judges are people, they have their own wants and needs, and they work for a living. And that's why you have to be humane. You don't dispense justice to your employees, even if you're in an organization. You try to reach their needs, to feel for them. And that's the difference between an associate justice who is charged with making decisions, dispensing justice, writing all these, evaluating facts, applying the law, and a chief justice who is also an administrator and a manager.
Must also be a good administrator.
Of course.
Okay. In fact, he is the chief administrator of the Supreme Court.
Looks like.
Looks like. Now, you will be coming from the outside, assuming that you are appointed Chief Justice, how would you lead the Supreme Court? Because you're coming from the outside. And how will you deal and lead with 14 justices of the Supreme Court?
I don't have to deal or lead the justices of the Supreme Court because they themselves are leaders. We will be coordinating with each other. We will be cooperating and we will be working together. The leadership of the Chief Justice lies in running the machinery of the judiciary smoothly and efficiently as possible. I am sure there are problems of employees, their salary structure, the wages structure, and their tenure of office. I'm sure there are lots of problems. And procurement and equipment, those would be the details. And probably you have to evaluate whether there's a need for delegation of powers, considering that it's quite decentralized. You know, all those details. So that makes a difference between being a Chief Justice and a justice.
Were you involved in the past as head of an association or a body?
I was Executive Vice President for Legal and Audit of Benguet Corporation.
Oh.
And I resigned with the position of CEO.
CEO, that means
Chief Operating Officer.
Chief Operating Officer. When was that, Attorney?
I retired at the age of 55 in 1998. I was there for 16 years. So I rose from the ranks as group manager, and I dealt with labor unions, collective bargaining agreements with miners, and strikes and whatever, almost everything.
You are related to Attorney De Castro?
Which one? There's so many.
The older one. The older one.
The older one.
Arturo De
Arturo?
Castro, yeah.
He's my husband.
Your son is also Arturo.
Yeah, actually, I have 3 children who are lawyers, and so I have spun off our conjugal partnership, the law office, into a law firm with my children. That's why I was able to, retire since last year. But I'm still, I have to advise them, so they face in.
Okay. Any other? Okay, that's all.
Thank you very much.
Thank you also for coming. Okay.
Thank you,
ma'am.
Congressman
Thank you, ma'am.
Tupas.
Thank you, ma'am.
Thank you, ma'am.
Okay, you may call the next.
The next candidate to be interviewed will be Secretary Laila M. De Lima of the Department of Justice.
You may take your seat, Honorable Secretary.
Good morning, Your Honors.
Yeah.
I understand that I have the option to either
You want to start?
sit down or stand up. Maybe
Okay.
I'll be a little bit
You want to stand up?
energized if
you want to be
Thank
stand
you.
up? Okay. But the problem, Honorable Secretary, is that if you will be in a standing position, the camera might not be able to catch your face. No, that's no. Your pretty face. Because the camera actually is there on the corner, and the camera takes your picture where you are sitting down. If you want there, okay also.
I'll probably
but,
have
but
the-
the camera at the back will not be able, will be focusing your back.
I'll probably have the option also to sit down later if I feel the need to.
Okay, just tell
But
us.
maybe initially I can.
Okay, just tell us then, no? Okay.
Thank you, sir.
Now, upon request of the Congressman Tupas, and without objection of the members of the panel, Congressman Tupas will be the first to ask the questions. Okay.
Thank you, Justice Peralta, Mr. Presiding Officer, and members of the JBC. But before I ask just few questions to the Secretary of Justice, may I just make a very short manifestation, if I may be allowed.
You may proceed.
Yeah, thank you. Pero yung time ko, wag magrana. Kasi there was a decision by the Supreme Court that isala 7-member itong council. And today, I communicated, Mr. Chairman, with my counterpart in the Senate, si Senator Francis Chis Escudero. And as of now, wala pa kasing decision ang Senate and the House kung sino ang uupo talaga sa JBC. We still have to discuss with the Speaker of the House and the Senate President and Senator Escudero and myself kung sino talagang uupo. Pero as of last night, nag-usap lang kami ni Senator Escudero, and he was very gracious na sinabi niya, at least sa interview, ako raw muna ang uupo. So, this is just temporary. Although ang decision, we received the decision of the Supreme Court na iisa lang ang member ng Congress, but by 2 o'clock today, we are filing a motion for consideration. So, as of now, siguro we will just officially communicate with the chairman of the JBC or presiding officer kung ano ang decision ng Senado at Kamara. Pero for the meantime, andito muna ako, at yung ibang question ni Senator Escudero, ako na rin ang magtatanong. So that's all. May I proceed now, Mr. Chairman?
Yeah. Go ahead.
Good morning po, Secretary.
Good morning, Congressman Tupas. Good morning, Your Honors, sirs and madams.
Ano po yung pakiramdam na kayo po yung nakatayo dyan instead of kasama namin kayo dito sa JBC?
Mahirap po ang pakiramdam ko ngayon. I'm of course a bit tense, a bit nervous. It's not easy to face your peers in a body such as the Judicial and Bar Council.
Kasi, okay, go ahead.
And I even just admitted to the media that I'm not sure whether I'm emotionally or psychologically prepared at this point to be facing this very crucial body because of a personal tragedy besetting our family. My father is very ill, so it pains me that I had to leave him in his bedside just to confront yet again another challenge in my life.
Yeah, we wish him well, Madam Secretary. We wish him well. Your father. Natanong ko lang yon because for the information of the public, kasi kasama ka namin sa JBC. I just want to go straight na lang sa substantive question. Under the rules, JBC, parang Rule 4, Section 5, Paragraph 1, that one of the disqualifications, yung madi-disqualify yung aplikante dito, is a pending regular administrative case. At matagal na rin natin na pag-usapan ito sa media, di ba? Alam na rin ng publiko na merong administrative case na dalawa na ito'y dun sa TRO, sa GMA case na referred by the Supreme Court ngayon doon sa IBP. So, magbobotohan ako yung target ng JBC, magbobotohan sa Lunes, which is July 30. At ang usual na ginagawa, pag may pending administrative case, hindi sinasali yung mga aplikante, kahit naka-interview, kahit may psychological examinations na pasado, pag meron pa ring pending case. So without touching on the merits of the case, Madam Secretary, ano pong masasabi niyo doon? Kasi para sa akin, importante yung sa application nyo itong pending administrative case.
Yes, thank you for the opportunity to articulate my thoughts on that. And indeed, it's a very important issue because I think there have been oppositions filed to my nomination and invoking that as a ground, as a reason, the alleged pendency of regular administrative cases. Now, I actually the records will bear me out, Your Honors, sirs, madams, that I filed last week I submitted a letter to the JBC, to the Honorable Council, and setting forth my arguments why those cases now pending with the IBP should not be considered as a ground for disqualification.
Pero very briefly lang para malaman natin, just cite yung pinaka-important lang na basis.
Yes, we take the position, Your Honors, that at this point, those cases now pending with the IBP have not yet ripened into regular administrative cases as may fall within the contemplation of the JBC rule. Under 139B po ng Rules of Court, meron ho dyan yung tinatawag na preliminary determination of merit. That's why I filed an urgent motion with the IBP asking for a preliminary determination of merit and the summary dismissal of the cases. Now, preliminary determination of merit on the basis of the pleadings so far filed, meaning the complaint and my comments, because these cases originated from the Supreme Court and I was asked to comment, I promptly filed those comments early this year, but only that it was only this year, it was only very recently, on July 3, that these cases were referred to the IBP for investigation and recommendation. Now, kung ganun po, merong requirement na preliminary determination of merit. Now, pending that preliminary determination of merit, hindi po siya masasabi nating regular administrative case. It has not ripened, or these cases have not yet ripened into regular administrative case because they have yet to pass the hurdle of that preliminary determination. Hindi po ito naiiba sa mga procedure din, let's say sa ombudsman and even sa preliminary investigation. It could not have been the intendment of the JBC rules or even the rules of court that the mere filing or the mere pendency of a complaint, just a complaint, is already a disqualification.
Liwanagin lang po natin. Yung disqualification pag regular administrative case, disqualified, no discretion na yung JBC. Pag hindi pa na-ripen yun into a regular administrative case, may discretion ang JBC whether to disqualify or not. Pero kanina po, gusto ko lang talaga maliwanag ito. Nakausap ko ang ating chairman, member of the Justice of the Supreme Court. Parang ginagawa nila ata, tinitingnan nila kung may prima facie. Kung may prima facie case, pinirefer nila sa IBP. Hindi ba ito may prima facie na po dahil na-refer na sa IBP?
I beg to disagree. I don't think that is really the intendment of the rules. I'm looking at Rule 139B of the Rules of Court. Nandyan po nakasaad yung procedure na there should first be a preliminary determination of merit every time, or if there is a complaint, referred to the IBP. Preliminary determination of merit. And yung Supreme Court nga po, even if sila ang nag-require ng comments sa akin, there should have been some pronouncement in the resolution referring these cases to the IBP that there has been some finding of prima facie or whatever.
Okay, so hindi na rin ako mag-delve dito kasi ito yung importanteng pag-uusapan rin ng JBC when we come now to voting na yung nominee. Yung pangalawang tanong ko lang po, di ba nung impeachment, yung isa sa mga articles of impeachment, yung partiality, closeness to a president. Diba? Isa yun, isa talaga yun. Although hindi namin napagtuunan ng pansin, hindi na umabot Article 1 yun hindi na umabot doon. Pero isa yun sa center ng impeachment complaint. May mga naririnig-rinig tayo, like for example, the Secretary of Justice, di ba? Malapit kay Pangulo, yung Secretary of Justice. May mga nagsasabing sektor na kina-question yung, di ba, dapat apat yon, proven competence, integrity, probity, and independence. Yung independence, yung kina-question nila pag sinabi na, Secretary Laila de Lima, ako, ang independence niyan, baka baka pag in-appoint ni Pangulo yan, susundin na lang lahat sa administrasyon na yan, di ba? So very briefly lang, anong masasabi niyo dito?
Unang-una po, hindi po nakasaad yan sa saligang batas, sa mga rules, JBC rules, na the mere fact that you are part of the administration of the sitting president of the appointing authority, that the mere fact that you're an alter ego, that is already a ground for disqualification. Now, time and again, there have really been appointments of cabinet members by the incumbent or the sitting appointing authority. And secondly, yung haka-haka pong yan, yung apprehension na this particular cabinet official who is an alter ego of the president would tend to be beholden to that of appointing authority, it remains to be just really a speculation, an apprehension, a possibility that can go either way. It can either that you be beholden really in your actions, in your behavior, in your decisions, or not at all. And again, history would prove that there are those who prove themselves to be less than capable of high sense of independence. And I don't want to be judged at this point that I would be beholden to the appointing authority. You have to look at my records, Your Honors. I've been with an independent constitution, an independent constitutional body, which is the CHR. And before that, I was a private practitioner. After the CHR, then the Secretary of Justice. And each of this position entails a particular mindset or perspective, a frame of mind. I can always adjust also to these perspectives. I'm an alter ego, and therefore it presupposes or it presumes that I agree with the policy pronouncements of the President as an alter ego. At this point, that I'm an alter ego of the President.
So, sigurado let's say kami, or ang mamamayan, tsaka JBC na once na let's say, yung Secretary of Justice, let's say, Chief Justice, magiging Chief Justice ka na, assuming Chief Justice Laila de Lima, hindi ka beholden kahit kanino.
Your Honor,
sigurado ba yon?
Yes, I would not have accepted the nomination if I'm not sure.
Okay, ngayon
the strength of my character.
Sa lahat ata ko ng mga aplikante, kayo ata yung pinakamaraming may opposition. Which is parang natural naman kasi kayo ata yung pinaka-controversial sa lahat naman ng aplikante. So maraming mga opposition. Parang isa doon, binabasa ko lang kanina, sabi, napakatagal raw ng petition for review. Nandito yung mga mga prosecutors natin. Matagal ba talaga? Yung ditong mga opposition, matagal raw yung petition for review ma-resolve ng DOJ.
I'm not going to deny that there are really cases which go beyond the prescribed period of disposition. And the described period is 60 days. Meron ho talagang mga kaso that goes beyond the prescribed 60-day period of disposing. Pero ganito po yun. It really depends on the cases. And I'm not the one who really resolve petitions for review. What I do is make sure or remind my subordinates that the undersecretaries are the ones who in the first place would resolve petitions for review. And we are trying to improve the disposition rate in our institution. I've been going around, or I've been making rounds in our various prosecution offices, making a personal appeal for them to improve the disposition rate, because the target disposition rate is 85%. But I keep telling them that my personal target is for zero backlog of the disposition of cases under preliminary investigation.
Anyway, dito yung mga ano natin dun sa DOJ, kasi ako maraming reklamo rin sa akin, kaya yun yung question, yun yung gawa natin ng paraan, nasabi na rin Secretary. Secretary, natatanong na kanina sa mga nauna dito ng aplikante, yung degree of, yung na-accept mo yung degree of criticism, di ba, sa Korte Suprema. Inuulit ko, di ba, parang sa 3 branches of government, kayo, binabanatan kayo sa executive, sobra-sobra kami sa Kongreso, sobra-sobra rin. Pero ang tolerance natin, mahaba, di ba? Pasensya. Ang reklamo ng iba sa Korte Suprema at saka sa mga courts, meron kaagad, may penalty kaagad pag meron kang criticism, pag i-criticize mo. Pag naging Chief Justice po kayo, ano pong may reforma ba tayong mangyayari dito?
I would try to espouse also a higher degree of tolerance on the part of the judiciary in terms of, let's say, the contempt powers in relation to sub judice rule. Ang problema ho natin ngayon yung sub judice rule kasi medyo nami-misapply na ng certain judges that is considered already as a gag on public discourse or public comment, extending even beyond the parties, but even to media and non-parties. Now, I always find it a bit questionable. Meron naman ho tayong mga standards set forth or laid down by jurisprudence on what would constitute really contumacious. Malaki ang leeway dyan because we have to be concerned, or we have to really be conscious of the time-honored constitutional guarantee of free speech. Now, itong mga cases na to, mga public trials, including criminal cases, including the Maguindanao Massacre case, ay ito hindi ho mga ordinaryong cases. And it's these types of cases are public property. And therefore, public comments, public discourse should be, or public debates should be encouraged. So it is only when I adhere to, sa law school nga ho, ang natatandaan ko dyan, yung test ng clear and present danger. Now, the utterances that are perceived to be contumacious or disrespectful of the court and the judiciary should be proven to present a clear and present danger to the administration of justice. Yun lang po yun.
Okay, clear. Mr. Chairman, just last three questions na lang, no? Kasi pag sinabi mong Secretary Justice de Lima, Secretary Laila de Lima, parang yung TRO, di ba, bumabalik? Yung dignify ito ng Supreme Court, no? Order. So, although napaliwanag mo na rin yun, di ba? Pero ano yung delineation doon? Let's say, as a lawyer, di ba, as public servants, ano yung delineation doon sa sunod tayo na sunod, sige, bawo tayo, at yung tatayo tayo na, oops, teka lang So, meron ka bang concept?
Can I just take water?
Yes, please.
I'll drink water. Okay, so my alleged defiance of TRO.
Yeah, pero ang question ko is not really the alleged defiance ng TRO, but your philosophy, your principle. Pag naging Chief Justice na po kayo, sakasakali, di ba? Parang gusto ko lang malaman din kasi naisip ng tao na, nagde-defy ito sometimes, di ba? Pero ano yung delineation doon? Kasi naging independent na rin kayo sa Constitutional Commission, naging Secretary of Justice kayo. Yes. Hindi pa kayo elected official, pero may delineation ba doon na bow tayo, takpan natin mata natin, sunod tayo, or may point na laban tayo? So what's your philosophy there?
It's always on a case-to-case basis. And ang ano ko po dyan is that orders, in order to be worthy of respect, should really be those that are issued with due respect also to the rights of the parties concerned. Illegal orders or illegal decisions are not worthy of obedience.
Even by the Supreme Court?
Well,
let's say an unconstitutional order. Let's say patently unconstitutional. We've been here before, di ba? Kami sa Kamara, nangyari na rin sa amin yan. Di ba? Na, let's say, feeling namin at tingin namin, patently unconstitutional order ito. Kailangan pa rin ba sundin yun?
We used to labor with the impression that the Supreme Court can never do wrong. What they decide on is actually, so to speak, the word of God. So it's almost sacrilegious for us lawyers to be defying orders and decisions issued by the Supreme Court. But in this day and time, in this age, we have it has been proven time and again that it's not as infallible as we think it is. These are human beings. There are cases that have been decided which fall short really of the standards required of them. or there are really cases which reflect the individual biases, prejudices, and even the tendencies or discriminatory tendencies of members of the court. In other words, they're also prone to mistakes. And when mistakes are done, there are remedies. But there are situations when remedies are not there.
So that's clear. That's clear to me.
Thank you.
JBC versus Commission on Appointments. Baka magkaroon tayo ng constitutional amendment, di ba? Although I am not one of those subscribing to an immediate constitutional amendment, pero may mga moves ngayon sa leadership ng both houses. No? Assuming na mag-constitutional amendment tayo, yung itong pagpili ba sa pag-nominate sa members of the judiciary, including ombudsman, ay kailangan ba nating pagpatuloy itong JBC? Itong composition na JBC ang nag-nominate? Or babalik tayo doon sa, yung iba, gusto na bumalik doon sa Commission on Appointments. Nasabi nila, mas transparent yun, mas talagang mabusisi yun. So I just want to know your personal opinion.
I'll go with the current system. I'm one with...
JBC.
Yes, the JBC. I'm one with the minds of the drafters of the 1987 Constitution. That, the reasons, we all know the reasons why that power to select the nominees for members of the judiciary, including the Supreme Court, were transferred from the CA to the JBC.
Masaya na ho kayo dyan?
Masaya na ako doon. The reasons for this transfer from the CA to the JBC had time and again in the 25 years of history of our Constitution, in the 25 years of that kind of a system, had been proven that it's less prone to partisan considerations, to partisan influence. It may not yet be perfect, factually or realistically. That has not been achieved. The zero influence from political or partisan considerations, but at least compared with the old system, I think this.
So yung isang politiko pwede na dito. Sa ngayon, isa lang eh. Last main question, to be fair to Mr. Chairman, to the other members. Let's face it na naging controversial po kayo, di ba? Because of a lot of issues and because also of the campaign of the administration na itong kampanya ng tuwid na landas. At ngayon, after the impeachment, alam rin natin na at least sa perception ng mga constituents ng Kongreso na kahit paano meron rin mga personalan rin sa loob na may away rin ng konti dun sa loob ng Supreme Court, yung mga ibang justices. At kailangan nila ng unifying factor doon. Yes. So assuming na isa kayong controversial na figure, 52 years old lang po kayo, do you think nag-fit kayo doon sa role na after impeachment, lahat ng taas ng standards ng ating mamamayan, tapos bagong Chief Justice, may reforma ito, kailangan you will be parang first among equals na magli-lead sa ganitong talagang yung pag-reforma ng sistema. Kaya niyo po ito? Tingin mo, fit kayo sa role na yan?
Sa totoo lang po, initially I had some apprehensions because, it's such a crucial post, it's a crucial institution, and then my age, but you mentioned about my age, young, quote unquote, but I'd like to think that my being young, quote unquote, is more of an advantage. And in fact, it's really an advantage. I don't think that my youth would pose any disadvantage. First, I would have the opportunity really to institute needed reforms. Reforms would always take time. I would have the energy and the dynamism to respond and to attend to the needed reforms. And I would have, my being young would afford me enough opportunity to reestablish values of consistency, predictability, stability, which are hallmarks of a strong justice system. Ilan lang po yun sa nakikita kong advantage ng aking pagiging young.
Pagiging bata.
Pagiging bata, quote unquote.
Relatively bata. Like for example po, 52 years old pa lang kayo. Pag na-appoint kayong Chief Justice, you will serve, di ba, under the Constitution, 18 years po yun. parang itong si Chairman Justice Peralta, hindi na maging Chief Justice ito. Kasi mas bata kayo sa kanya, di ba? So marami kayong masasapawan doon. Kanina, si...
Pwede mo mag-comment ako doon?
Sige, please.
Yan nga po ang parang nagiging intriga or yun ang mga parang riniraise sa akin na, you know, if you get it, you will be serving 17 or 18 years and you have practically disenfranchised, except for one, I think, I would practically disenfranchise everyone from within. Pero hindi naman po dapat yun ang tingnan natin. Ang titingnan ho natin is kung kaya po ho ba to serve as Chief Justice and institute all the needed reforms. And I will try, of course, to heal all the wounds, especially those that arise from the impeachment. And I will try to really just have the strength of character to make sure that not only that I decide correctly or come up with the right decisions, but also to be able to fight for the right decision and to advocate for the adoption of the correct decisions by the rest of the court.
Kanina si Dean Bautista yan, di ba? Yung una-una. Sabi niya, mas maganda may term limit eh. Kasi bata rin siya. 48 years old siya. Sabi niya ako, willing akong mag-sign ng waiver, 7 years lang ako. Para at least hindi ko yan, si Justice Peralta, pwede pa maging Chief Justice, di ba? At yung iba pa. Willing rin po ba kayo? Kasi 18 years, para tagal-tagal ata.
Well, with due respect to Chair Andy ho, hindi naman ho ito political position eh, na pwede yung mga sharing. No, it's a mandate, and since the Constitution prescribes for the mandatory age, then we abide by that. But of course, no one can prevent any sitting justice or any sitting Chief Justice from resigning for some reasons or from severing. And of course, be subjected to, let's say, impeachment proceedings and be removed. But as far as the Constitution says, it is up to 70 years of age. It cannot be subjected to sharing.
Pag na-appoint po kayo ng Chief Justice sa kasakali, you intend to serve it until you reach the age of 70, 18 years from now?
God willing, and barring any significant developments in my life, then I intend to serve it.
Salamat, Mr. Chairman. Salamat, Secretary, Madam Secretary.
Salamat din po.
Attorney Cayusa.
Thank you, Mr. Chairman. Good afternoon now, Secretary De Lima.
Hi.
Yes, I know. It's surprising because we meet under different circumstances. But nonetheless, I have to do my mandate. Now, ma'am, there are several issues against you, but I'd like to focus on matters that would affect the legal profession. For instance, there are sectors in the IBP that are invoking for a more independent bar organization because currently the IBP is under the supervision of the Supreme Court. If you become Chief Justice, to what extent would you grant the IBP the independence, particularly with respect to guarding its own ranks, disciplining its own members, and other matters that would promote the legal profession?
I would still give it to the IBP to police its own ranks, to investigate and to file charges, and also to weed out the legal profession of undesirables. Now, I will have to leave it also to, but it has to remain with that institution. That institution has been envisioned to really improve the quality of service of lawyers and also to attend to their particular needs and provide for benefits professionally, especially. So it has to stay, IBP. Its powers have to remain. Now the Supreme Court, of course, it has overall supervision. Now the Supreme Court still have also the power to discipline erring lawyers and undesirable lawyers. So I don't see much of a desired change. It's just really more of a question of putting the right people in the organization, people with vision, people with vigor and dedication to be to serve as inspiration, especially to the younger set of lawyers.
Thank you, ma'am. I ask that because there are many sectors who would want to follow other bar associations around the world that are totally independent of their Supreme Court or the equivalent of the Supreme Court. Moving on, you have been in the CHR, you're currently the Secretary of Justice. How have you shown that you can remain independent, notwithstanding the views or the opposing view of the appointing authority?
Again, may I just paraphrase or reiterate what one of my answers earlier, that, well, I used to be a private practitioner specializing in election law. Then I was suddenly appointed as CHR chair, then suddenly appointed as the Secretary of Justice. As I said, each of these positions, we can say, have different perspectives, mindsets, and mind frames. Now, each of these positions would entail or demand a lot of challenges differently. But the matter of being independent, or the matter of having a high sense of independence, pretty much a question of the character of a person, and knowing fully well the responsibilities that he or she has when discharging when discharging a particular post. Now, I am an alter ego, and I am presumed to be in agreement with the policy directions of this administration, or most, if not all, of these policies. I would not have accepted this position if I do not agree with the thrust of this government for good governance and accountability. The matuwid na daan. It's a very laudable, very noble ideal. And in fact, it's something that I wish to also inculcate in the judiciary if and when I take this, or if I get this post. So I have no problem with that. It's in the character, it's in the various and multifarious tasks that have been assigned to me, both as a private practitioner and a public servant. I think I will be up to the task or the challenge. I know that people expect me to really discharge my mandate with the highest sense of independence.
Thank you, ma'am. With respect to the selection process of the members of the judiciary, having spent some time already with the Judicial and Bar Council, and if you become Chief Justice, you become ex officio chairman, what changes would you propose with the JBC in order to make the selection process more efficient, more credible?
Well, more efficient and credible selection process. Well, I think I need to really, my top of the mind idea there is to be totally oblivious or not consider political endorsements from politicians. I think any potential conflicts of interest or anything that would really put a question on your sense of impartiality or independence should be avoided. And one of these is really to do away, to discourage, if not completely, do away with political endorsements. Now, efficiency is a matter of really, possibly assigning particular specific committees or subcommittees within the JBC, and not just assign to the Secretariat some functions that are currently being discharged by the Secretariat. Now, it has to be a hands-on evaluation of the qualifications of the members, of the applicants or the aspirants for judicial posts.
In your opinion, has the JBC achieved the gender equality in the selection process of the members of the judiciary, particularly in the appellate courts?
Well, gender equality is not really a question of numbers. It's not a question of how many are male and how many are female members of the judiciary. Because indeed, gender equality is never meant to be really gender blindness. Gender equality does not really advocate for making special favors or favorably considering women over men, or that it does not mean that we have to embrace new stereotypes about men and about women. It doesn't mean that we tilt the scale in favor of women all the time. It's never meant to be that way. In the final analysis, it's always a question really of who is more suited for the job, who is more competent. In the final analysis, my view is that all human beings, all persons, regardless of genders, are human beings and with inalienable rights. And part of that right is to be treated fairly. So it's all just about qualifications and meritocracy. But I do notice, ma'am, that more and more women are getting appointed to the judiciary simply because they deserve to be so.
So they should also be considered for the position of Chief Justice. Now, for my last question, ma'am, you have shown your abilities in different capacities, but I think there are many who would like to ask this. Where would you consider your inclination, your personality, and your capabilities to be most appropriate in the executive, in the judicial, or in the legislative branch of government?
In any of these positions. Although if I have to join the legislature, that means I have to first join politics and run for elective office. Now, in that sense, it's not as it's not as compelling, in the sense that I've never really been a politician. I don't know if I would fit as a politician. Now, right now, I had experience with the executive, or I have an experience with the executive by virtue of my position now. Although I have some powers which can be deemed quasi-judicial, attorney general powers, and when I was at the CHR, I presided over that collegial body in public hearings. And when I was a secretary or clerk of the House of Representatives Electoral Tribunal, then I remember I drafted resolutions and decisions for consideration and approval by the members of the tribunal. Now, I think my personality, I easily adopt to the environment, and no problem with me in any of joining any of the three branches.
Thank you, ma'am, and I look forward to seeing you again under different circumstances. Thank you, Mr. Justice.
Thank you.
I have no further questions.
Attorney Mejia will now be the next.
Thank you, Mr. Chairman. Magandang hapon po.
Magandang hapon. My
seatmate in the JBC. Sisimulan ko po ang aking katanungan kaugnay sa panunungkulan ninyo sa DOJ. Ano po sa palagay ninyo, Madam Secretary, ang makabuluhang nagawa ninyo sa bilang DOJ Secretary kaugnay sa pagpapabilis po ng mga resolution, particularly ng mga criminal cases? Kasi po, mayroon pong perception yung iba na mayroong delay, there's delay in the resolution of cases because there is a lack of prosecutors, etc. Can you share with us your thoughts on that po?
There are various reasons why we cannot seem to achieve the ideal of really speedy disposition, meaning within the mandated time frame, yung zero tolerance. Although yun nga po ang aking target, dapat zero tolerance. Pero nakita ko nga po na there are several factors or reasons kung bakit. Nasabi nyo na po yung isa, na kulang po talaga kami ng prosecutors. If I'm not mistaken, ang vacancy rate namin is nearly nearly 20 or 25%. Although meron hong mga nakabinbin ngayon na mga possible appointments of new prosecutors under the old law, and isusunod na rin ho namin yung under the new law, the National Prosecution Act. So isa po yun kasi right now po ang average load or case load ng aming mga prosecutors ay would stand at about 600 or 700 cases per year. That's the PI, that's the trial, and then meron pa ho tayo sa PI. But ang ano ho namin dyan is that we are coming up with new rules na rini-review ko na po na in the hope that we can help or we can achieve speedier resolution or disposition of cases.
Salamat po. Ang dami-dami pong pumapasok na text questions at saka sa Twitter na ibinigay sa akin na lahat may kaugnayan sa inyong alleged defiance, no? Yung pong issue na yon. Pero nabasa ko po ang inyong paliwanag, ang inyong liham, at ang posisyon ninyo doon ay there was no such defiance. So I think it will be a wrong premise to ask you that question if your position is that there was no defiance. In any case po, I would like you to give this opportunity to once again address po that particular issue against you, that the allegation against you that you have willfully defied a lawful order of the Supreme Court when you prevented the departure of the first couple. And should you be given the chance po of, for example, rethinking your position, will you do so? Thank you po.
Drink again.
Go ahead, Madam Secretary.
There is no defiance of the TRO. I did not willingly defy the TRO. It was not a question of defiance, but it was a matter of the former president hurriedly and prematurely trying to leave the country, first, in spite of the pendency of the cases, and second, in spite of the non-service as yet of an official copy of the TRO on the very day that the former president was trying to flee or trying to leave the country. Alam naman natin under the rules of court, ang service ay dalawa lang yan, yung personal service or substituted service. As of November 15, nung late afternoon nung November 15, nung inisyu po ng Supreme Court yung TRO, wala ho kaming natanggap. It was only the next day. And another thing is that, so it was more of a hurried attempt or premature attempt on the part of the former president. Na they claimed to have a copy of the TRO, but they seem to have failed to recognize that that TRO was conditional. Kaya nga po nung 3 days later, nung November 18, nagpulong uli yung nag-session or nagpulong uli ang Supreme Court, and precisely to tackle that matter. That as of November 15 and even 3 days later, wala pa hong full compliance with the conditions set forth in the TRO. So paano ko po ba masasabi na I defied that TRO? Why am I now being questioned or vilified for something that is not supported by the facts? So there is no defiance.
Thank you po for clarifying that. Those who have nominated you for the position attribute their motive to their nominating you to their desire to restore public confidence in the Supreme Court, and this is articulated in their nomination letters. Do you think there is indeed such a loss of confidence in the Supreme Court? And if there is, how will you restore that confidence?
It's really a difficult question. I would not want to make a very sweeping conclusion or statement on that. Rather, I would say that yes, there are times or there are actions on the part of the Supreme Court which tend to lose the people's faith and trust in the judiciary. Not only the members of the Supreme Court, but also the members of the judiciary as a whole. But there are moments, there are cases, there are actions on the part of the Supreme Court which are laudable and worthy of commendation from the general public. Now, yes, I think the challenge now for the new Chief Justice is to how to really restore complete trust and confidence of the general public. And I'd like to say that the Chief Justice, who is expected to regain or to improve the level of faith of the public in the judiciary, may not necessarily be or have that type of persona that conventional wisdom has prescribed for such a post. The Chief Justice, it's not enough for a Chief Justice to be the embodiment of, it's not enough for him to be perceived as something that is someone who is unreachable or untouchable or with limitless or unfathomable wisdom. No, it's not. People nowadays have shown the tendency to invest and be interested in the affairs of government, including the judiciary. And therefore, we need a Chief Justice who, while maintaining a high sense of independence and impartiality, is not perceived to be out of touch with the needs of the public. A Chief Justice, yes, must be wise, but wisdom is not necessarily equated to, with really getting all the right answers or being fully acquainted with laws and jurisprudence, but more so that he is able to come up with well-reasoned decision and actions that are, at the very least, perceived by majority of the people as credible and bona fide. Thank you.
As my final question po, there is a notion, rightly or wrongly, that a Chief Justice or a member of the Supreme Court should have a masteral or a doctoral degree. Kasi yung nakalipas po, merong mga Harvard degree and other prestigious universities. Do you think a masteral or a graduate study degree should be considered in determining the competence of a Chief Justice? Thank you.
I missed that point. I wanted to say that also, that in my opinion, it's not a matter of having numerous academic credentials. It's not a matter of getting more diplomas. It's not a matter of writing books and be associated with institutional or educational institutions. To me, what is foremost, what is most vital is the character of the person. I can say that all of us, all the nominees for this crucial post are, in their own right, qualified. Some would have a certain advantage over the other, but definitely qualified. Each of us has his or her own weaknesses and strengths. So what would be most crucial in terms of perceiving what type of a Chief Justice one can be is his or her character. It's actually a rare breed. Thank you.
Thank you. Good luck po. And thank you, Mr. Chair.
Salamat din po.
Justice Lagman.
Okay. Thank you very much, Mr. Chair. Secretary, good morning or good afternoon. So, Secretary, what do you think is the advantage if any, of having a lady like you sit as a Chief Justice?
Good question, but difficult question in light of the position I articulated earlier, the gender equality, about the gender equality.
Yeah.
But, you know, as a lady Chief Justice, I think I'd like to say, this may be a bit cliche, but I'd like to say that I would have the passion to be able to discharge the mandate conscientiously and with fealty to the Constitution and the rule of law.
Okay. So if you will be appointed, you will be the first lady Chief Justice in the country. And what do you think are your strong qualities which would give you the moral ascendancy to lead the court?
Strong qualities
As
as
a lady.
a lady
Yeah.
Chief Justice. Well, may I just say again that I tend to be passionate and I tend to really put so much zeal and dedication to any and all assignments that are given to me. And it's the strength of character. Maybe it's in the genes and maybe it's in the type of upbringing that especially my father as a role model has shown to me. We are very conscious of, we know exactly what is right, what is wrong. We know exactly when to fight for your own ideals in life.
Okay, Secretary. Considering that the Chief Justice is seen as the face of the judiciary, is it important to you, if you will be the Chief Justice, to perform well in public satisfaction surveys?
Definitely, Your Honor. I'm aware of that the new Chief Justice should be able to really be that face which embodies the ideals of an independent and effective institution. And therefore, it is quite imperative for the Chief Justice to perform well.
Okay. Now, as the Chief Justice, in case you will be fortunate to be appointed, how do you want to be remembered?
Just like my incumbency now, or my tenure as the Secretary of Justice, I want to be remembered as someone who provided the leadership, the vigor, and the hard work for the institution to be a trusted and respected institution. That's always my aim, even way back in the Commission on Human Rights. The institution as a respected and trusted institution which furthers human rights, or which has for its primary mandate the protection and promotion of human rights. Now that I'm the Secretary of Justice with the all-encompassing and very broad range of mandates and assignments given to me under the law and under the practical necessities of daily operations, that's what I'm trying to achieve. And to a certain extent, modesty aside, I think with the DOJ, I am able to do that. Much more needs to be done in terms of really further increasing or improving the public's faith in the judicial system. And I would want to do the same with this institution if blessed enough with the faith, with the trust.
With that in mind, how do you propose to address the serious problem of alleged corruption in the judiciary.
Yes, I agree it's a serious problem.
Yeah.
Actually, well, in preparation for this public interview, I was trying to craft an appropriate vision and mission.
Yes.
Although I have to say that I'm still unable to really craft, in the exact language or words of that vision and mission.
Yeah,
but I do believe that I think if I were to state in broad strokes what my vision would be, I'll focus on two major goals
What are those?
and reforms. Number one is to be able to achieve the ideal of judicial independence in its fullest extent. Now, much has been said, especially in the past months, that it is imperative for us to preserve the independence of the judiciary from outside influence.
Okay.
But I think I need to emphasize that judicial independence does not begin and end with the independence of the Supreme Court. Judicial independence has to be nurtured also in the case of the lower courts.
Yes.
The Supreme Court is the court of last resort.
Yes.
But our lower courts are the first line of defense against injustices. And therefore, especially the lower courts, they're the ones which conduct trials. They're the ones which have the most interaction with the public. They're the ones with the opportunity to be able to do significant impact on society. So since they are the first line of defense against injustices, it is just as crucial that they should be shielded from outside influence. And I say this in practical terms that I would want to make full use of the fiscal autonomy of the Supreme Court in terms of making sure that none among the members of the judiciary, not only the judges, but the administrative clerks, the staff, and the sheriffs, process servers, they do not have to rely on anyone for their needs. Not a single centavo from any one party or non-party, not a single bar of staple wire, or not other benefits from, let's say, from local government units, from certain groups, from even influential practitioners and influential law firms. They should be totally shielded from any outside influence. And therefore, it is important that everything the courts need for their own operations should be provided. That's one point. I have the second one, Paul.
Yes, okay, please.
In broad strokes, again, I think there is a need for a paradigm shift among the members of the judiciary, especially in relation to the concept of public service. We have gotten used to, people have gotten used to really showing so much deference to judges and justices. Fine, nothing wrong with that. The only problem is that there are recipients of such deference which do not prove to be worthy of such respect. Respect is a two-way thing.
Okay.
So the paradigm shift, it's more now of the concepts of accountability and humble and dignified service should be at the forefront of any judicial reform. And I do believe that for as long as we address those 2 points that I just articulated on, everything else will fall into place.
Okay.
Thank you.
Thank you very much, Secretary. Good luck. Thank you.
Justice Hermosissima, sir.
I was concerned with the principles, the human rights, which advocate equality of women, the gender equality. Why is that so? When, as a matter of fact, men have always placed women on a pedestal. You see,
that's precisely part of the problem.
Perhaps it was because, well, in the Bible, the woman was only made from the rib of Adam. Or perhaps by Rudyard Kipling's statement in Luxley Hall, when he said, all thy passions matched with mine are as moonlight unto sunlight, and as water unto wine. Well, we recognize your impeccable academic and educational attainments. But then we believe that that is not enough to be qualified for judgeship or for even as Associate Justice of the Supreme Court, and with more reason for Chief Justice of the Supreme Court. How do you equate yourself to the position of Chief Justice, considering your lack of judicial experience and perhaps the administration of 24,000 employees of the judiciary? What are your thoughts on this?
Thank you, sir. First of all, I fully agree that academic credentials are not enough to qualify one or to be considered an ideal occupant of such a crucial position as a Chief Justice. As I've been mentioning early on, it's really a matter of character. It's the strength of character and the clarity of vision that an aspirant has to make him or her an ideal candidate for the position. In the first place, sir, judicial experience is not among the qualifications provided in the Constitution. In the first place, administrative skills and administrative experience also are not prescribed as a qualification. Otherwise, the best candidate would be the court administrator. Now, in particular reference to my experience, sir, I take this that if and when I'm appointed to the post, taking on the administrative responsibilities is just the same as what my experience had been when I joined the CHR, when I joined the DOJ. Administering the affairs of an institution does not really require a special or some special administrative skills. It's more of your determination to know exactly what the institution needs in the operational aspect and having the determination also to put in place the needed reforms. I have had some substantial experience in running institutions. CHR had 13 administrative regions all over the country. We have lawyers. DOJ, especially DOJ, is not just the main office, it's not just the National Prosecution Service. I also supervise and have control and supervision over 10 constituent and attached agencies. Now, in the National Prosecution Service, we have prosecution offices nationwide, and we have thousands of personnel nationwide. And in terms of administering the DOJ and its attached and constituent agencies, remember, sir, that these agencies under my control and supervision span the whole gamut of the country's criminal justice system, from investigative to prosecutorial to rendering of opinions, legal, to prosecution, and even correction, the correctional aspect of the criminal justice system. I do believe, sir, maybe Supreme Court would be a bit different in terms of the gravity of the responsibilities or the gravity of the needs and challenges of this institution. But given, again, my background, I think I would be up to the task. Although I'm used to really assuming posts, hitting the ground, and immediately thrown into situations where I have to learn so much. My learning curve has always been quite short whenever I assume new posts. Thank you.
Well, if you are as convincing then as you are convincing now, I think you are well qualified. Thank you.
Maraming salamat po.
Attorney Mejia. Attorney Mosngi, Secretary Mosngi, please.
Maraming salamat. Mr. Chairman, magandang hapon ho, Secretary Laila.
Good afternoon.
Before anything else, gusto ko lang sabihin na isang malaking karangalan para sa akin na gampanan ang inyong tungkulan biing kalihim ng kagarawan ng katarungan sa pagkakataong ito po. Madam Secretary, kayo po ay tanyag, kayo po ay sikat sa ating bansa. Marami po ang inyong tagahanga at marami po kayong supporter. Maraming naniniwala sa inyong mga adhikain at sa mga tinutulak niyong reforma bilang kalihim ng ating Justice Department. Maaari ko ba yung tanong, ano ho ba ang sa tingin ninyo ang inyong di kaanyayang trait or katangian? What is your worst character trait, Madam Secretary, you think?
Mahirap po yung tanong na yan. I would rather that other people would really provide that answer, but I can try. Ang isa pong nakikita sa based on experience po, minsan po masyado pong malambot ang puso ko. Actually, in public or when in discharging public duties, I project a very strong image and no nonsense personality. Pero ho, sa totoo lang, malambot ang puso ko. And there are times that I find myself in a quandary, in a dilemma on how to really address specific situations because of that. At ang pangalawa po, malambot nga po ang puso ko, pero grabe naman po ang temper ko. my staff can attest to that. But I'd rather that you don't ask them about my temper. But I'm blessed with a very understanding staff. Alam naman nila yun na hindi naman ako namemersonal kapag po nagwawala ako paminsan-minsan dahil hindi ho masunod yung gusto ko o hindi masunod yung hindi magawa yung nang tama ang pinagagawa ko. I think yun po. Kasi yung, well, although I understand or I know that my bad temper is also in my blood. Thank you.
Salamat po. Marami pong...
Wala na ba?
Meron pa. Marami pong naging kritisismo sa inyong alleged na panlabag dun sa temporary restraining order noong panahon ng gustong lumipad sa ibang bansa ang dating Pangulo, Gloria Macapagal-Arroyo. Sa pagkakataong ito, gusto ko pong itanong sa inyo, kung natanggap niyo po ba ang kopya ng temporary restraining order bago nakarating si dating Pangulong Gloria Macapagal-Arroyo sa airport, susundin niyo po ba ang kautusan ng Supreme Court?
Depende ho. Titingnan ko na muna ho yung language, the tenor, and the terms of the order. As it turned out, conditional po yung TRO. So kung natanggap ko po yun at napansin ko, yun ay kung napansin ko na subject pala to conditions and I had no way of validating at that point kung nasunod na po yung conditions or any condition, then hindi ko pa rin ho yun susundan.
Madam Secretary, if we deal with absolute terms now, there is no condition, it is unequivocal that the Supreme Court is directing you to restrain your department from enforcing the watch list order. Would your answer be the same?
I would be in a real dilemma. But it's something that I cannot give a categorical answer now. Although it was my position at the time also that we did intend to file a motion for reconsideration of that order. So sa tingin ko po, at that time, yung perspective ko po nung time na yon ay hindi ho kami masyadong napakinggan bago nag-issue ng TRO. But again, let me just say that I do not want to dwell further on that because the first two reasons that I have already explained or elaborated on are enough to justify my actions. Thank you.
Sorry, just a few more, Secretary de Lima. Dalawang tanong na lang po, Madam Secretary. Kung sakali po nakasamaang palad na kayo po ay ma-disqualify sa kahit anong kadahilanan sa pagiging kandidato at nominado sa pinakamataas na katungkulang Chief Justice, ano po ang magiging reaksyon ninyo dito at ano po ang gagawin ninyo bilang kalihim ng kagawaran ng katarungan?
Definitely, I will not be happy about it, but I will find out and determine whether there is an available remedy for me. I know that the JBC is sort of, well, we can say the sole judge. The question of qualifications or lack of it. But perhaps there would be an available remedy for me. And that is why in my letter to the JBC, I fervently plead for the exercise of this council, the Honorable Council, of its discretion, judicious discretion. And it's even more than the discretion because of that position that I'm advocating, that at this point, those complaints, as referred to the IBP, have not ripened into regular administrative cases. Although on the practical side, just to be on the safe side, I have asked the IBP to expeditiously resolve those cases, hopefully in time for the supposed deadline that was reported in the media as proposed by the Honorable Congressman Tupas. Is it July 30 deadline? And that is less than 1 week. Just for the safe side. But I maintain the view that those complaints at this point should not be considered as legal grounds for disqualification. Salamat po.
Mr. Chair, I forgo with the last question that I have in mind. I think it's been previously asked. I give the floor to the Chair. Maraming salamat po, Secretary Dalay.
Salamat din po.
I will just ask a few questions, Madam Secretary. Now, it's your position that disbarment case that was filed against you, it's now pending in the IBP, has not yet ripened into an administrative matter?
Yes po, that's my position.
And that you also filed a motion for, what motion did you file?
For,
to determine if there is
for
merit?
Preliminary determination of merit and summary dismissal.
You're borrowing what they usually do in the courts, judicial determination of probable cause. It's likened to that.
By analogy, I actually invoked that argument that just like the rules of the ombudsman, just like the rules on preliminary investigation, because there's a rationale for that. Otherwise, every potential candidate will be held hostage to any and all types.
But may I remind you, disbarment cases are either filed before the IBP or before the Supreme Court.
Yes, Your Honor.
I think we agree on that. If it is filed before the IBP, then the Board of Governors shall refer the same to the investigator.
Yes, Your Honor.
And the investigator will determine if there is a merit to the petition.
Yes. That's the preliminary determination of merit.
And require already the filing of an answer. If he determines that there is a case against the lawyer, then he will require the respondent to file the answer.
Yes, sir.
But if a case is filed before the Supreme Court, it is filed before the Supreme Court, and therefore the Supreme Court determines if there is a prima facie case against the respondent, then that rule is not followed. Because that rule is only followed if the disbarment proceedings is filed with the IBP. But in the case of the Supreme Court, and this has been the practice, if a petition for disbarment is filed against a lawyer before the court, then the ponente will study if there is a basis to require the filing of the comments.
Yes.
He may recommend the dismissal on the ground that probably the complaint is not verified, or the complaint comes from an anonymous person. Or number two, if the petition is in accordance with the form and substance, then the ponente will recommend the filing of a comment. And after the filing of the comment, then the ponente will determine if there is a prima facie evidence to proceed with the investigation before the IBP, or recommend to the Supreme Court for the dismissal of the case on the ground that there is no prima facie evidence. Now, the procedure that was undertaken against you, Madam Secretary, is that petition for disbarment was filed before the court, and the ponente recommended that the respondent should file the comments, and I think that's what you did.
Yes,
now,
several months ago.
Now, the ponente recommended to the court en banc, and the en banc was unanimous, no, in referring the case to the IBP for further investigation. Now you file a motion for a predetermination if there is merit to it. Do you think that the investigator will go against the resolution of the court referring the case for further investigation and considering further that the institution of the petition for disbarment was filed before the court? I ask you this because indeed we have agreed that we will determine the qualification of the nominees by the 30th of July. If you filed a petition, if you are fortunate enough that they will entertain your petition for the determination, yes, if there is merit to your petition, the petition will not end. If the investigator finds that there is no merit, the proceedings will not end in the hands of the investigator. It will still go to the Board of Governors of the IBP. And the Board of Governors of the IBP will determine if indeed there is no merit. And if there is merit, then they can reverse. They can reverse the position of the investigator. So, with time constraint, today is Tuesday, and then by Monday, do you think that there is sufficient time to resolve your problem about this disqualification? I have to ask you this for the benefit of the public and also of the members of the council.
I do realize, Your Honor, that time is not on my side, and that's why I take that position, the first one. Well, it's a layered argumentation on my part. First, that I take the position that does not ripen into regular administrative cases. I was listening to His Honor explain the difference between the Supreme Court proceedings, a complaint filed direct with the Supreme Court and filed with the IBP. Now, there is nothing in the resolution, Your Honors, in the resolutions of the Supreme Court in those cases, because two have been consolidated, the Rivera and the Pedrito case, and then the Sunjam. Now, in both resolutions, there's nothing there about a determination of some kind of a probable cause or a prima facie or a preliminary determination. There's nothing there about referring the cases to the IBP for further investigation. The wordings in those resolutions, if I remember correctly, Your Honors, referred to the IBP for investigation, report, and recommendation. Now, if these are referred to the IBP for investigation, report, and recommendation, then I don't see why we have to consider the mere referral from the Supreme Court to the IBP as already a finding of a preliminary merit or a preliminary a prima facie. Your Honors, this is indeed my dilemma, and I don't want others to be in the same footing, or equal footing, or in the same situation as I am in now. Because as far as I'm concerned, Your Honors, I promptly responded to promptly complied with the directive of the Supreme Court for me to file comments. It's beyond my control. Now, the complaints should have been either already disposed of by the Supreme Court. Now, I know it didn't see fit to do so, but it doesn't mean that the referral of those complaints are an indication that there is some preliminary finding or determination of merit.
Okay. Now, I respect your opinion. Another thing is this: disbarment proceedings are long process. No, it's a long process because you might be called for clarificatory proceedings. You might present your witnesses. The recommendation, the findings of the investigator is merely recommendatory. It will go to the IBP. My concern is this, Madam Secretary. You're now appointed the Chief Justice. No? any recommendation of the IBP, whether to dismiss, to suspend, to disbar, will come to the court. And you can just imagine the problem that the court will be confronted with. If you are now the sitting Chief Justice and the recommendation is disbarment or indefinite suspension, what do you think are we going to do? You are not the sitting Chief Justice. Is it not that it would be more prudent if let us first decide that disbarment proceedings before anything else?
I would have wanted that, Your Honor, that those disbarment complaints should be decided in time for the deliberations of this body, maybe July 30 or maybe after July 30. But as I said, it's actually beyond my control. Now, let me say, Your Honors, that I'm confident that this would be resolved in my favor. I don't think there are enough grounds. In fact, one complaint, of course, I don't want to be accused now of trying to influence the IBP, but as an advocate and as the very person being subjected to that unnecessary process, I don't think that I deserve to be disbarred. Look at the grounds.
No, it's not only disbarment. It may be lower than that, no? The petition is for disbarment, but that's not necessarily mean that the IBP will recommend your disbarment. It may recommend warning, admonition, or even suspension. So that is what is prayed for.
I remain confident, Your Honors, that this will be thrown out.
Now the other things. Let's forget about that Circular 41. Is it Circular 41? Yeah, Circular 41. Anyway, it is not yet been resolved by the court. But generally, if you're a practitioner, you receive an order of a court, not necessarily the Supreme Court. A TRO is issued against your client. What should you do as a lawyer? A TRO or injunctive brief is issued by the court against your client, and you're not the lawyer of the client. What are you supposed to do? Let's forget about Circular 41. As a rule, what should you do?
If on the face of the order it appears regular, it appears to be clear in its terms and tenor and language, then no option but to obey. But there are situations where there are times.
In other words, it is conditional. So it will depend on the face of the TRO. You will have to go over the face. You have to go over the TRO. And then it will depend on whether to follow or not. It will depend really at what is stated in the TRO issued by the court.
If I'm not a lawyer, I will consult a lawyer and ask.
You're not the lawyer. You're not the lawyer of the litigant. Mm-hmm. You will still maintain your answer?
Well, as I said, if I'm not a lawyer, prudence dictates that I consult a lawyer.
Yeah, but if you're a lawyer, we are all taught that we will, in fact, it is in our oath that we will obey the lawful orders of the court. If you think that the order of the court is not in consonance with the rules, are we not supposed to follow the order and then file the necessary motion to lift the issue of TRO before the court and state your grounds why a TRO should not have been issued, rather than to disobey it on the ground that on its face it is not in accordance with the rules?
The regular and ordinary course of action is to do just that.
Yeah.
Oftentimes, that is the situation. Oftentimes, litigants who know very little or nothing about nuances of the law would do that ordinarily. But then again, sometimes the prevailing situations and circumstances of a particular case would warrant a different treatment.
Yeah. By the way, Madam Secretary was a classmate of my wife, San Beda. Okay.
My regards to her, Justice.
Now, I have my last question. No? This is not a question formulated by me, no? But I will be causing an injustice to that lawyer who gave me that question. And the question is simple. If you are now the Chief Justice, and in the past, and you have something in the past or background, that if it is exposed or made known to the public as a Chief Justice, it will cause embarrassment to you and the judiciary? They have something in the past or background? It is a question fed to me by a lawyer, and I said it will be an injustice if I will not ask that question because I accepted it.
I would always have an option, Your Honor, to do what is the right thing. That's all I can say.
Okay, just a note. I would just want to quote what Justice Holmes once said about a candidate. No? Being a jurist is not about the logic of the law. It's not what we know of the law. It's not logic of the law, but it is experience on the law. Now, candidly, no, do you possess the necessary experience in order to become the Chief Justice of the land?
I have the experience in terms of knowledge and application of the law. It may not be as extensive as the rest, or it may not be as extensive as the current members of the judiciary or the Supreme Court. But I have what it takes. I have it in me that with enough industry and dedication and determination and focus, I would be able to exhibit that competence in the command of the law, in the study of the jurisprudence. I'm always a good student of law, and experience also experience would be quite helpful.
Thank you. He also agreed that one of the qualities of a Chief Justice or even a jurist is judicial temperament.
Yes,
yeah, of course.
Yes, Your Honor.
I think that's one of the most important qualities because you will be dealing with experienced jurists and 14 at that. No? Now, I will read to you of a definition of a judicial temperament, and then tell me if you agree with the definition and tell me why. Okay. A learned lawyer from the United States of America who was monitoring the qualification of jurists in America wrote this one, and he said, the candidate must have the qualities of patience, open-mindedness, courtesy, tact, firmness, understanding, compassion, and humility. A candidate should be able to deal with people calmly and courteously and should be willing to hear and consider the views of all sides of a case. A good jurist needs to be even-tempered, yet firm, open-minded, yet willing, and able to reach a decision confident, yet not self-centered. Do you agree with that?
Yes, Your Honor, fully.
Yeah. Or you agree
Completely.
fully? Yeah.
I agree.
Do you have these qualities, Madam Secretary?
I do not profess or I do not pretend to have all those qualities.
But you can approximate.
I can
probably.
approximate and I can adjust.
Okay. Thank you. That's all, Madam Secretary. Thank you for coming. Thank you.
Maraming salamat din po. Thank you so much.
The Council will have a few minutes. What? We'll have a recess. We'll take our lunch. We will continue at 2 o'clock in the afternoon or 2:30. Just tell me that 2:30 na? It's already 1:15, so we'll start at 2:15 probably. Give us 1 hour, no? Okay. Thank you very much. Session is suspended.
Good. Oh, thank you. I will skip this afternoon's Kanina muna ngayong hapon, I have to go back to the house.
May naisip kayo, sir.